Committee to order. And the first item, I believe, on the agenda is we have a series of about three, I think, score extension requests. So let's go ahead and start with the first one, which was dealing with Heather Thompson. So I'll give everyone a minute to read through her extension request. Ready to discuss? I believe kind of a summary. She passed the BEC in October 2014, and then in August of 2015, her father-in-law was diagnosed with ALS and eventually passed away. And she now is back on track studying and is requesting to extend the expiration date into the Q3 testing window. And now I don't know how this works, Wendy. In terms of voting, I'm chairing, so I don't vote, right? And Stephen does.
As chair, have you not voted before?
I thought the chair didn't vote.
I think the chair can vote
In the committee.
Yeah.
Okay.
Mm-hmm.
Okay.
Before you discuss or get into these, I also provided in the documents the applicable rule and the history with regards to this board approving extensions. That document is titled Score Extension Rule and History.
Hello?
We can hear you, Stephen. Go ahead.
Can you hear us, Stephen?
Hello?
Stephen, can you hear us?
I can't hear. I can hear you now.
Have you heard anything so far?
Yes.
Heard anything so far? This is Ben Glover.
No, I just hear you.
Come again?
I can only hear you.
Can you hear me?
Steven, we're trying to get you patched in. Just hold on 1 second.
Okay.
Steven, can you hear us now?
Yes.
I think we're good.
Can you hear us now?
Yes, I can. A little echo, but I can hear you.
Okay. Okay, Stephen, I think what Charlene has introduced the first score extension, and then we also have a document that has the applicable rule along with this board's history of granting extensions on score extensions.
Okay, I'm looking at it right now.
And it may be better to at least summarize the other two. So let's look at all three of them since we have three score extensions, and that way we can kind of because we don't want to be inconsistent here. And just to summarize the prior ones, it looks like ones that we have accepted in the past have all been medical except for a technical issue that occurred. So in looking at Lator Cook's, hers is going to be a medical, and Natalie Hill's also medical. And also, I should say that Natalie Hill has passed 2 parts and not passed 2 parts. I don't know if I don't believe that's made a difference in the past, but that may be a point to note.
Also, I'd just like to clarify that I think I put an expiration date in the middle of a testing window, and I've received updated information that they don't expire till the end of an exam window.
On Lator Cook, she is only lacking 1 part, and the Heather Thompson, I believe, is lacking 2 parts.
One point on Lator Cook, she was requesting an extension of, if I remember correctly, of auditing. And if you look at her reg, what's the expiration date says 5/29/16. Is that, when did you say that changed?
Well, it's the end of the window, so that historically would have been May 31st, but now they're adding 10 days into the dark month, so it would be June 10th would be the official expiration.
Would that be the same for her auditing portion?
Correct.
Yes, all of them are 10 days into the next. So
Okay.
it would be better to just say at the end of the window.
Okay. I mean, what I was asking though is she wasn't asking for a reg extension, and if I read her medical, if I remember it correctly on the letter from her doctor, it says she wouldn't be able to come back until June the 4th. So I mean, didn't give her much time either way to do the reg part.
I think on the exception policy on the second page, it appears to me she was asking for an extension of both sections.
Okay, now I was just reading her email address, or email. Maybe I read it wrong. Yeah, you're right. I may have got this confused. I guess my biggest concern is that if we open this door too wide, I mean, it almost just takes away the rule we have in place that, 99% of everybody else managed to do, to meet the time frame for which they can, their scores are good. I understand medical conditions. I mean, the only reservation I have on this one is just, the medical issue is at the very, very end, at the very end of the time frame. You've got 2 years or whatever it is. You've got the, long period of time since end of 2014 to pass all 4 parts.
Are you referring just to Lator Cook, Stephen?
Yeah, I think it'd be easy just to kind of take them one at a time and kind of discuss them, and then, you know.
Okay, well, in that case, let's start with Heather Thompson, since she's
Okay.
the first one listed on our agenda here. So Heather Thompson is the one who has passed BC and audit, but she has not passed FARD Reg, and she's asking for an extension through September's test, or the Q3 testing window, due to the passing, illness and passing of her father-in-law. Question.
Wonder if she was involved in the care of her father-in-law, because ALS, I've seen that with a good friend, and it is time consuming, and with 2 young boys, it would be difficult on a regular schedule of sitting for the exam.
It is a devastating disease. There's no question. Did we receive, Wendy, any, I mean, I hate to say this, but any validation or any?
No, not in this particular one. I think on the medical issues we did.
I mean, this is the professor speaking here, who, unfortunately has
Here's every excuse.
learned to question everything.
But what I did get was her exam history. So she has attempted FAR 6 times. She went through about around 2000 of where she sat for the exam 4 times, and then she quit sitting and started back in 2014. So when you combine those two, she sat for FAR 6 times. Reg, she sat for around 2000 4 times, and she has not sat recently.
Yes, I would also. I'm hesitant to approve anything without some kind of backup information. I really don't want to set a precedence that you can just say something and we just all agree that that's trusting. And again, I know that, but she, for all we know, she may not have been involved at all, other than that this occurred, and it wasn't her father, it's her father-in-law. Again, I hate to be the skeptic here, but
I mean, that's why I was asking if she was involved in his care.
I can offer to email her this evening and see if she gets back to us before tomorrow.
I was just going to say, maybe we should decide, assuming we had like a death certificate or some confirmation, would it change our vote? And then let Wendy know whether we wanted to get that or not. 'Cause I'd hate to ask her for that and then say no. Yeah.
Will her audit scores still be good at the end of Q3? Or do they expire before then?
Because she gets 18 months.
it's 18 months.
So she'll go into 2017.
Okay.
But let's assume we had backup information.
If she was the primary caretaker for her is her father-in-law,
Her father-in-law.
if she was the primary caretaker and that's what she did full-time, in addition to her job, I think that would impact my decision. But I think otherwise, while it's a terrible disease and it's a terrible situation, I think that we still have to follow our rules as well. I think I could potentially grant some leniency if she did confirm that she was the primary caretaker and she was going to work and then coming home and taking care of her kids and also taking care of him when she wasn't at work. I mean, I could lean that way, but otherwise, that's my opinion would be is that it's a tough decision. It's a hard decision, but I mean that's just keeping it in compliance with what our rules are.
Yeah, everyone has life to deal with too, so it's unfortunate, but we do have to deal with life while we're doing this.
So if we were going to ask for some verification, Wendy, it's hard to ask for a verification that you were the primary caregiver because how are you going to prove that? So, of getting a death certificate, I mean, I agree with Steve. I think my opinion would be, assuming we process they went through, then I think we should. I am on this committee, right?
Yes, you are. So go right ahead. Just speak right up.
Before I go any further.
Was I looking at you funny?
Yeah. No, it just hit me that maybe I should not be speaking. My feeling would be, it's that she's gone through a lot of details here. It would be really hard to look at all these details and not say she was not very involved in the process. So my thoughts would be to approve it. Now, whether we want to ask for a death certificate or not, I don't know.
Let me ask this. She's saying in the letter that she sat for FAR again and doesn't know until March 18th. Did we ever find out whether she passed FAR?
Yeah, she said in the email that she didn't submit a 74.
She did not.
Yeah.
Okay.
Our past history has been to approve because of sickness. Even though this is not her personal sickness, it's sickness of someone that she supposedly was caring for and very involved in the care for. So, correlation I would draw is that even though it's not her being sick, it was someone who had to be cared for that was in her immediate family.
And the way I interpreted it, though, is it wasn't, just going from the facts that she presented, she wasn't the caretaker. It just impacted her life because of her in-laws were previously involved in caring for her children.
Yes.
And because they were diagnosed with this, then she lost the people that were taking care of her boys, and so that made her, life more difficult to take care of her kids. So I hate these types of situations because they're it's a tough one. But I just don't without me seeing anything at all that she was the primary caretaker. It just makes it hard to approve this.
This is Trey. Can I make a suggestion? It says here that she worked for 17 years at the same Nashville CPA firm where she still works today. Am I reading that correctly?
Yes.
Is it possible you get some sort of letter or something on her behalf from their firm, or what? I mean, how could you maybe having the firm attest to? I mean, if she was the primary caregiver, she wasn't working, right?
Well, I also I noticed that she wants this extension through Q3. She's almost past FAR. There's nothing stopping her from sitting for reg and still having another window, because this window closes at May. June's no testing. Then there's July and August. So that's what she's asking for, is to have July and August, because she has to take FAR again. Okay. Didn't help.
I guess I'm making an assumption, but I would have assumed if that would have been a fact. I'm aligning here saying I was the primary caretaker of it eroded my free time having to care for my father-in-law. If it's just a request, and again, based on the facts, if it's just a request because, we were very close to my father-in-law, he died or he was sick, it took a emotional toll on our family. I think that opens up a whole lot of doors for everybody who experiences, situations, of family members being sick while they're taking sick or dying during their while they're taking the CPA exam. I just think that opens up way too many doors for future approvals for someone that says, well, my mother-in-law, my sister-in-law, my brother, whoever passed away. I mean, it's almost like I guess death happens all the time. Not to sound morbid about it, but I mean, that's my biggest concern on this.
Wendy, did she take BEC? Do you know about her history with BEC?
She's taken all of them at least 4 times. So let me get back to.
What did she make on BEC the last time? Did it say that?
BEC, is that the one you're asking about?
Right, because that's the one that's going to expire.
Oh, okay, 76. 76 was her most recent score.
Did we say that we typically approve these if it's the person who's ill?
Right.
Is that generally how we've done it in the past? So this would be a new precedent?
Right. That's the issue. It would be a new precedent, and
actually, I think we have in the past, since I've been on the board, it may be medical, but I believe we have actually excused people where they had deaths in the family and that sort of thing, not just theirs. If that, do you remember any? Did you read actually the full files on these, or is it just what was noted, Wendy? I was thinking that we had others just for the record, but
Karen did the research on the most recent ones on that history spreadsheet. Most of them were medical. But I guess we don't have on there whether it's medical with themselves or a family
Right.
member.
that's
Yeah,
where I was.
that would
That's
make a
all I
big
was saying is I think
difference.
we've had some where it was, spouse medical, et cetera, that obviously impacted someone's ability. And I'm all for the not going wholesale and doing anything, but
Well, I'd like to
We've
know.
also had.
I think that
We
makes a
also
big
want
difference.
to have a heart, and if the ALS is about as ugly as it gets, and if she was closely involved with the care, whether she was the primary caregiver or not, she could not focus, and that may be a last-ditch effort not to lose something, but it certainly is a legitimate thought to consider anyway. So.
Is this something we should get detail on and to make sure that we're not setting precedents, or are we decisive enough about this that we want to make a recommendation to the board, or do we want to get more information for tomorrow? So that's.
Well, let me ask you a question. Let's just say she was here in person, and we asked her, "Hey, are you the primary caretaker?" And she says no. We say, "Well, were you a caretaker?" Well, I don't know how you quantify it, but let's just say she says, "Well, I spent, an hour a day or 2 hours." When does it become enough time that would sway our opinion? And let me ask the last question. Let's say she's here and we asked her and she said, "No, I had no involvement whatsoever in our care." Assume the last fact. Does anyone object to denying the request if she's not involved in meaning the caretaker at all?
Am I on this committee?
No.
I am.
But
Okay.
No, you're not, but
Oh,
you
I'm
can
not.
express an
Oh, okay.
opinion.
I was just going to say that given the position, if we can, in fact, get confirmation that there was the death, that whether she cared for him an hour or 5 hours or whatever, the impact that had on her family unit. And while she may not have had to do things directly, the emotional and she has children, her husband, and the rest of the family. It's just, to me, if there was a death, whether she cared for him at all, I think she was down and out for a while and unable to probably. That's when you lose a parent, your world stops, and everybody else's keeps going, and that's the way I've described it in the past. And I would give her the benefit of the doubt if we have, personally, if we have a death certificate.
I don't think the fact whether she's a primary caretaker and to what extent is the factor either. It's an emotional thing to the entire family. So I don't think that's the issue. I think the question is, can we confirm the death, and are we setting precedents if it's in terms of it involving someone other than the person taking the exam?
Just play devil's advocate. How do we put a fence around this, and that someone comes in and says, "Well, my cousin, who I was very close to, died, or my best friend died." I mean, where do you kind of draw the line with, how extended of a family member does it have to be if we set a precedent that a death? Well, I agree, that is a very traumatic situation and emotional situation. Where do we draw that line? I mean, one could argue that my best friend died, and there's as close to a sibling as anything.
I think if you were going to draw a line, it would be immediate family.
But I don't think we have to establish that today. So maybe what we need to establish today, again, is that there was a death, and have we made an exception for deaths in the family in the past? In the recent past, 2013 on, or... I don't think we're going to get that answer today. So can we maybe request the information and then push this to the board vote tomorrow? I just don't want our committee to make a recommendation if there's not been precedence. I'd certainly want the board to weigh in.
Going back to, let's not ask for the additional information unless we know. Verification of all these facts, and then we get it and we say no.
Well, I think the only thing we're asking verification for is the death, and that should have come with her letter. Frankly, that's just a standard. You don't just you should provide evidence, just like if you have a medical issue, they always provide evidence.
Right.
So I don't see anything wrong with requesting confirmation that there was indeed, that this did indeed occur on this date.
Well, either if we think we're going to approve it, if we get it. But I think if we
we're not going to know whether we'd approve it unless we also know whether this has been done before, right? So I'm asking for both. I'd like to know if we're voting for something that has not occurred in the past. I'd like to know that. If all we've done is make exceptions for people who had their own personal issues, then we would be doing something. Exactly. I'd like more detail. Can we get that?
Yeah, it was. She went based off of the minutes of that meeting. So if the details are in the minutes, then we can share that.
We need to wait until we find out if this has ever happened before and find out if there was an actual death.
Just to get confirmation for the record.
I agree.
Agree? Okay.
Agree.
Would we like to have a motion do we want to have a motion for that?
I'll make a motion that we find out if we have approved extension as a result of a death, and we will confirm the death of her father-in-law, and then we can decide tomorrow.
I'll second that.
Right. Let's have a verbal vote.
Stephen Eldridge,
Aye.
Larry Elmore, Gay Moon,
Aye.
Charlene Spiceland.
Aye. Okay, let's move to the next one, which is Lator Cook. He is asking for an extension for audit, which expires this month or at the end of this testing window. Actually, it's audit and reg.
Yeah.
And she has not passed far, and her reasoning is from a surgery that she has offered backup for.
So just to confirm, the expiration dates on her auditing and her reg is 5/31.
It will actually be June 10th.
That's right, the 10th day. So both of these is June the 10th for both of these. Yeah.
Correct.
I mean, the only hesitation I would have on this one is, both of these were passed back in late 2014. So, I mean, there's been a lot of time to pass the FAR portion. How many times has she taken the FAR?
I do not have her information right now on exam scores. I'll try to email Alan, see if he can send them over.
That would be my only concern, is that, you know, we're pushing up to the expiration date. For example, you know, you're a month away or so. April, May, you got 2 months to go.
My comment on that is she had her surgery on April 4th, but typically you don't have that surgery until you have had a period of health issues that you have endured. Now, I'm not a doctor, but my guess is she didn't just decide on April 3rd to have the surgery, so there could have been some health issues that would have precluded her from being able to focus on the exam.
I also am a little hesitant to think for us to get into determining how sick she was for what period of time. I don't think anyone says, "Wow, I really want an extension. I think I'll have a surgery." So, I mean, I think there's a danger if we start second guessing how things occurred.
Good point.
I'd be inclined to grant her the extension.
Would you like to make that motion?
Make a motion that we recommend to the board to grant it.
Second.
All in favor? We'll have a. If there is not any more discussion, then let's have a vote. Karen, please.
Stephen Eldridge,
Aye.
Larry Elmore, Gay Moon,
Aye.
Charlene Spiceland.
Aye. That takes us to the next one, which is the.
Would you point out the time, clarify for the record, the amount of the extension that is being given?
It would be through the
Third quarter window.
Q3 testing window.
Testing window for the record then.
Right, for the record. That's going to be our recommendation to the board. That brings us to Natalie Hill. She is requesting a score extension of reg. For a year.
She does indicate that she would be grateful for any
extension. Okay. I'm not. Is BEC expiring in April? Is that why she came up with the April date?
I think she was asking, yeah, to be the same as the BEC. So really, wouldn't that be?
That would be April 30th.
April 30th.
I guess one factor on this one that's a little different is that there's not an event that's going to take care of the problem. So it could be just a continuing problem, and we give this extension, and then it still continues, and time passes, and then another extension. And in the other cases, you know, someone passed away, that's over with as far as the event. the surgery will take place. That's an event that will take care of itself. But in this one, problem is not going to clearly stop. I mean, there's no end to the problem.
Right. She's going to continue to have pain.
I mean, if she were saying I'm having surgery to deal with this issue, or I had surgery, but when you just say you're having pain, and the pain kept me from taking the exam or studying, then that's a little bit different from the other normal cases that we've seen. Where do you stop with the extension?
And I think a year extension is a little long.
Do.
I mean,
Her her doctor's signature, and the doctor that she's actually giving us information from is a family practice doctor. And I would think if you have serious back problems as she's described, you would have an orthopedic involved.
Right. An orthopedic or a neurologist.
I would be
One-
going to
Neurologist.
if I had those.
Right. Right.
Has she been able to work?
Didn't really say that either.
she does say she's full-time employed in there.
But she doesn't really say whether she's been missing work.
I feel like a nice and passionate person here today, but I just think that if a person's able to work, I mean, I would assume you'd be able to study. And that's just, I'm making some assumptions. I don't have this condition, but I do also agree with what Larry says that, if we grant an extension, is that going to even, the problem hasn't been solved. There's no notification or documentation that, that I've solved the problem, I fixed the bulging discs, or whatever. I'm not a doctor, so I don't know what all that means, but
I'd be willing to extend through the Q3.
What is the end of Q3? I can't.
It's the September, October 10th now because of the 10 days or whatever. I'm not sure what the weekend has an effect on that too. So, but it normally would be the end of September.
And that gives her 2 testing.
That would give her
cycles.
the rest of this time
and
and
next one.
another one.
Okay.
Wouldn't it be? It would normally be the end of August, and they get
Oh,
10
so
extra,
it's the end
10
of
extra
September.
days.
Right. I'm sorry.
Okay, so September. Okay.
September 10th.
10th.
So I was right. I mean, originally confused myself.
Okay.
But that would give her, she has until the end of May, and then she has a break, and then she has another 2 months, but she can only take each part one time. But she could take both parts.
Her history shows she's taken each part at least once. I'd have her history.
Which also indicates that she, in theory, has done the bulk of the studying, so there should be nothing prohibiting her from having the time to take those. I mean, it's not like you have to sit down and start studying all over again or from scratch. She's had the time to study. So that would be my inclination.
I just go back to my point. If she's able to work, I'm assuming she was able to work. I would assume if you could carry on your daily work function, then you should be able to study. I mean, that's an assumption I'm making, but.
When you're flat on your back for weeks at a time, you have a lot of time to possibly study. That's just my.
That's true.
my
I'm not a good one to weigh in on this because I had 3 herniated discs in surgery and completed my PhD. So, probably not going to be right there. Sympathetic.
I just think we go back. I mean, my earlier point that there's nothing in here to indicate that she's going to do something to eliminate the problem or to try to eliminate the problem. So it puts us in a spot. If she doesn't pass it during the extension time, then she comes back and says, well, I made a 74. If I'd had just a little bit more time, and my back started hurting again. I mean, if you think of it similar to someone who has migraine headaches and happen to have a headache on that particular test day, they could very likely have another headache on the next test day too. So I'm just saying there's nothing here indicating that there's a fix to the potential of it happening again.
Want to make a motion?
These are tough decisions. They really are. And I think we have to go back to what you said a while ago about precedent. And you don't want the rule to be in place just so that we can forgive it every time.
Yeah.
I just think this one's different. I just think this one, without having a surgery scheduled or more of a definitive plan, I'd approve this one.
Well, the history that's been given to us, we have approved all of them if they had medical reasons.
The question here is this because it is not, there's no indication to say that she doesn't have pain right now, that she isn't going to have pain next week, that she's going to have pain in a year. So to Larry's point, what he's saying is she could come back. If we give her an extension of any kind, she could come back and say she's still had pain and hadn't been able to take it. So that does put it off to another board, but
what does it say in the doctor's note? It says it has affected her ABL.
is it?
I don't. Yeah. What is that?
This has caused severe pain, which has affected her ADLs.
It's normally assisted. The DL is daily living.
Activities of daily living.
Yeah.
There we go.
Yeah.
Activity of daily livings.
Okay, so looking at the history, then, if someone is just sick on test day, well, there's not a test day anymore, I guess, because you can go online, and so get my question then, because I mean, back in the good old days, there was a test day, and if you were sick on that day, you had a reason to say you needed to do something different,
But you also had to wait 6 more months, so. We have a motion on the floor. Do we have a second?
Okay.
The motion from Larry was to not accept this extension or not allow this extension due to the fact that there was not a imminent event or an end to the event.
What does the rule say about it? I mean, is that a valid
There isn't.
way to deny it?
This is the problem. There
The rule is
isn't.
pretty
Vague.
not vague. It gives a lot of power to the board.
Right.
And it just says that the board may, in particular cases, extend the term of conditional credit, notwithstanding the requirements of these rules, upon a showing that the credit was lost by reason of circumstances beyond the candidate's control.
So it doesn't per se mention medical? Beyond the candidate's control.
It just says circumstances beyond their control.
because it had been on the board since day one, like Casey What,
Casey.
what are your thoughts
I'm
on
glad
that?
he went to my elder.
Don ducked.
I think that medical is something we can. Oh, I mean, I think that fits within the definition in the law. It's just a matter of whether it was an event that caused them not to be able to pass the exam. You know, was it? We all have medical situations, whether it be a cold or the flu or whatever. But is it something significant enough to keep us from studying and passing the exam? That's the judgment call we got to make, I think. So, thank you for asking.
So you think that this circumstance is a little bit unusual in that there's no seems to be a continuing problem, and that it will be a continuing problem unless she has.
I think my opinion would be changed significantly if it in here, kind of going along with what Larry said, if it said I had 3 bulging discs and I had to have surgery in pick a day, and the problem has subsided.
Yeah, that's my point.
Or if it said I've been able to work or do anything, it's affected my ADL or whatever that means so badly that I've been bedridden for 6 months and I can't focus because of the drugs I'm having to take or the pain I'm enduring. I think that's a different situation.
Well, this may not matter, but as someone who has had back pain and back surgery, I mean, you can have, not I'm saying that this is this person's situation, but you can have, well, I'll say this, I have had continuing back pain, and if I just lift, it could be something that's not even that heavy, but if you lift it the wrong way, you can go into extreme back pain. And I'll rewind that and say, I have gone into extreme back pain to where it's difficult to function. I didn't have back surgery right away. It took months. But at some point, I came to the conclusion that if I didn't have some back surgery, I would have to be functioning almost like a crippled person. So that was my experience. And I mean, it can come and it can go. And I know that from personal experience. So, I mean, I'll just share that with you. I don't know if it makes any difference, and there doesn't necessarily have to be an event or a cure or the cure. I mean, it could take months, years even, before you ultimately conclude that there's nothing else that I can do. So that's just some information. If it helps, good. If not, then.
I agree. I mean, I've got a cracked vertebrae, and I've had it since college, and it's just, yeah, you're right. Some days it's terrible, and some days it goes away. I don't know her situation personally, but
That having been said, and again, I had a lot of pain before I had the surgery, and I still passed my PhD. So I don't think that precludes you from being able to study. But
Could you pass? Did you do everything as timely?
yeah,
Okay,
absolutely.
You did. You were determined. Okay.
Yeah, I was pretty determined. So
I haven't had her issue, but I would be more inclined to give her a shortened extension. I can't do a year, but I can't.
would you like to make that motion?
You know,
There's a motion on the table, but it hasn't been seconded. So without a second, we need another motion, or
I would make the motion that we recommend that she is allowed an extension through Q3 of this year.
do we have a second? Any more discussion?
no, I would have seconded Larry's motion, but it doesn't matter now.
Then shall we have a vote? Karen, please.
Eldridge,
No.
Larry Elmore, Gay Moon,
Yes.
Charlene Spiceland,
That's not good. Maybe I should have just said yes.
Would we tie?
Yeah, we tied. So let's.
And the board chairman be a ex officio vote?
I believe we should take this to the board. Isn't that the next thing to do? We'll let the board make the. I'll present the history and we'll let the board vote. Okay, so that moves us on to the Pass Online updated for the state-specific ethics course revision. Do we have some background information on this? I mean, other than the letter and they're wanting to receive approval for this.
Okay, so they were a previously approved state-specific ethics sponsor of the 2-hour course. They have made updates to their course, so they are asking this board to approve their new course. Back in October of 2014, this board stopped approving any new courses while we look into the idea of potentially less or one course. That you revisited it in October of 2015 and chose to keep that restriction in place, and you were not approving any new ones. I wasn't sure exactly with this one. They were an already approved sponsor. So this is where we are. They have an updated course for you to review and decide if you would like to approve the updated course.
Is that? Sorry, go ahead.
I just made some notes throughout the document on some, I would say, minor issues throughout the course that I think need to be addressed before it's ultimately out there. But I'll let you all discuss.
I think the first thing rather than go into the details behind the course, we have to decide, because I believe the reason we said we wanted to approve was basically because we were trying to, or the intention was maybe to eliminate those outside vendors offering state ethics. So I believe that's really the question.
Is there what's the general requirement if we have someone that's previously approved and they just make updates to their course? Does that have to be approved?
Well, it didn't until we made the vote.
Well, all courses need to be approved initially, and then we have suggested that if there were any major updates to the course, it needed to come back to this board for approval.
Okay, so this will be considered a major update?
Yes.
Okay.
Wendy, do we have an update from the Tennessee Society on the progress of the canned course that we were going to use, Mr. Floyd?
I teach him to creep in, won't it?
Of course, that we'd refer to working with NASBA some to try to come up with a gold standard on this. Our concern, as we've stated before, is we've got 20 some odd different vendors that have been approved once. Many years ago, I think by Wendy's experience, there have been some submitted that were just inaccurate. This is a state-specific course. It seems reasonable. There would be one version, and it would be offered to all licensees, either as a part of the CPE requirement or as a part of the licensure renewal requirement. But we don't have a online course ready to present, but I would encourage the board to consider that as opposed to 20-some different versions.
Do you have any idea on the length of time? Right. Where we are?
We've met recently with Wendy, and Dr. Mark Stedman from ETSU is working on an update for us presently.
Would a year extension be appropriate so that we start a timeline that we've extended the approval for 1 year on this program with, and just let them in on the fact that with the different state specifics, we want to be sure that they're accurate, and it's only for 1 year. This approval.
Are you saying that if you approve this, it would just be for 1 year?
Yeah, I'm saying, is there any reason we couldn't say we have a 1 year extension so that we've got at least a cutoff time instead of the grandfather problem?
No, there's not.
Very detailed course, and I obviously didn't look at it for accuracy, but it's matter of fact, I got an email on the way down here this morning wanting to know if we needed to sign up the firm for this particular course for Tennessee ethics online.
Brett, do you have an estimate of when the course that you all are developing will be, I guess, published and ready to go?
I'm hoping that we can complete that this calendar year. Wendy may have as good of an estimate on that as I do. We met with Wendy, Dr. Mark Stedman, who's presented to this board before, professor at ETSU, and we've looked at the outline. We quite frankly think the outline needs to be updated and changed. There are some relevant materials in those outlines, that licensees should know. How many CPE hours do you need if you do governmental work? Do you need some Yellow Book CPE? If you're doing A&A, do you need some A&A CPE? How often but is it important for a licensee to know that there are 9 CPAs on the Board of Accountancy, or that the board staff is composed of a receptionist, a clerk? Some of that stuff is pretty important. Some of it we think is irrelevant, and it's all in the outline that's been approved by this board that's used to approve these vendors throughout the country. I don't know where all they're located, but I think many of them are out of state. Some that have been submitted course material to Wendy have been deemed to be totally inaccurate. I think Wendy had referenced one was using Texas statute in presenting the specific law and rules course on Tennessee law. And that, to me, seems a bit unusual, but unless you go back and see what everybody's presenting, how do you know who's presenting accurate information, timely information, relevant information? If you had something online that all licensees were required to hear the same thing, that were important to the board, and it could be updated as the board sees issues that come up for licensees. This is an issue that was clearly a problem last year. Let's make sure it's included in the material. It just seems to be more prudent. We feel like we'll have something. We've got the software, we've got the author. We would like to work with Wendy on trying to propose some adjustments in the outline, but I feel like during the current calendar year, we should be able to present something. We have the software in place. What we envision is something that's compelling, that has specifically what the board deems to be needed for the licensee to hear. Whether or not it should be 2 50-minute segments, and whether a licensee should sit and listen to someone live or sit in front of a computer for 2 50-minute segments, or whether it's self-paced and allows the licensee they can move along to complete it in less than 100 minutes or more than 100 minutes, depending on what the information is contained in the course and what the board deems to be important. Working through Wendy, we feel like we can identify those things, but we understand that this is something that would likely require committee action, or board action, or rule change potentially. If we worked within the existing rule, we feel like the board could approve a standard that all licensees have to hear, and how it's presented, how it's offered is really up to the board at that point. But I feel like we should be able to get something done over the next several months. We've got a mechanism in place. We really need to work with Wendy on enhancing that outline, because it's pretty loose right now. If you took a look at it, I think you would agree that nearly half of it is probably not relevant, and half of it is very important. There's probably some other stuff that needs, but it hasn't been updated in how long?
Ever.
And how long is ever? 10 years maybe?
Since the rule was enacted.
I think we just need to do some work on it, and we need to make sure we got the outline right. But I'm hopeful that we could get it all done within the current calendar year, working together with Wendy. We had hoped, quite frankly, to use some material that NASBA was producing and had been funded through several resources that they've been unable to develop in a manner in which we can, I guess, engage with it online. I think that's one of the reasons we've delayed the process this long, but we're going to move forward with with what we consider to be an appropriate course and let the board consider it. However, there may be other options out there that you want to consider at the same time. We just encourage you to identify what the licensees need to hear and make sure they're all hearing the same thing, because we quite frankly think they're hearing 25 different versions, many of which are inaccurate, inconsistent, and the outline is antiquated, and work needs to be done on it.
This specific course, and I looked at the things you marked, Wendy, but this is a good indication of how inaccuracies can get into these courses. And it seems to me we need to send this back to them. As a minimum, need to send it back to them with the comments that you've made here and ask them to address that and resubmit it. And at the same time, I think you may need to apprise them that the board is currently considering, eliminating outside vendors, or how we need to say that. Maybe that's not the way you say it, but let them know about the debate that's going on, because we've been talking about this for a long time now. And if we're going to move forward in the direction of trying to have one course that is really quality and accurate and what this board wants, we need to get on with that and make that a top priority. But if the TSCPA is going to do that, we need to do everything we can to help the process. If it's going to be somebody else, we need to, help them. But to me, we need to try to bring this thing to a reasonable, speedy conclusion. But I don't think we ought to vote on or approve this course as it's been presented without them addressing these issues here. So
I would also suggest, just as a consideration for when y'all send this back to this company, I'm not entirely sure that I would give them the right answers. I think I would highlight the wrong answers and let them go back and figure out what the right answer is and resubmit. Because I agree with Mr. Floyd that you've got issues of inconsistency, and as we all know from school, the best way to learn something is look it up yourself. And so perhaps it would at least help with respect to this one course to become a better product if we make them go back and try to figure out what it is that is correct. And I will say, for the record, I'm excited to see what the society can put together, because I do think that it would be nice to have something that we work kind of hand in hand with you all on, especially on some of these issues that come up repeatedly in one given year. We can try to talk with you all about, hey, maybe y'all can try to hit this thing off the pass for us with your membership. And the last thing I'll say is on page 23, in fact, that the attorney member can't have an active CPA credential from the state of Tennessee to be in this position. So we had noted there that the society doesn't provide a list of for public or attorney members,
right.
But I think what they actually say is the attorney member has to have an active CPA license from Tennessee as well, which is actually the exact opposite of what the statute says.
Okay, thank you. And for the record, I have the concerns of continuing to approve or even approving the number of courses that we currently have. And my main concern is that we don't have an oversight process. We don't have a process in which these folks have to come back and represent their course. And there's just whether it's one product that we offer from one sponsor or one product that can be purchased and then delivered. There might be different ways to do it, but content put together in one product, I think, would be better for the public and the licensees, for them to be hearing one thing rather than 20 different things. If you all released your suspension on approvals, I would have 10 people tomorrow wanting courses approved. So it will just continue to get bigger and bigger and more courses. So I am hopeful that we can can bring this around. And if the board decides at some point they do want to focus on one particular product, we can come up with, the things that we would want to see in that product, potentially put it out for an RFP, that type of thing, and go from that.
From our committee, I think it may be best to make some motion basically saying that, first of all, they need to correct it and then maybe decide whether we want to give a 1-year approval. So something to that extent, because we certainly don't want to indicate that it could go on for longer than that, at the very least. What do you?
You want me to make a motion?
I need a motion.
I'll make a motion that we recommend to the board to return their proposal to them for corrections that would be in line with our Tennessee state statutes, and put a limit of a year that we would accept it after any changes were made. Is that?
Want to simply send it back and ask them to represent, and then you determine at the next meeting whether it's approved?
That sounds good. We could, but I do think that somehow we want to indicate to them that this is going to at least be an annual approval or something, because we don't want them to think that they're going to get. I would not want them to put tons of work into this and then realize that we're only going to give them a year approval, and they have to keep coming back, and until such time that we decide on a product. So
what are we going to do if we have other vendors come back saying, well, I want a 1-year extension then, that we postpone decisions on?
Could you repeat that, Stephen? I didn't quite hear it.
We've had vendors in past meetings where we've denied the approval, if I remember correctly. Basically, we've suspended anybody needing any new courses. What if we have a vendor that we've said no to? They come back and say, "Well, that's fine. I want a 1-year extension, just like these guys." Yeah.
Wouldn't all those situations that I remember were people who don't currently have a state-approved ethics class? So, because I think there could be a distinction drawn between this current group who has a course, and I think we should, to the extent we're still allowing them to provide that, we should encourage them to keep it up to date, right? So I kind of hate the idea of not providing this, extension of a year or approval or whatever, so long as they get it corrected. But I think we draw the line with new people coming in, new vendors coming in, and saying, we want, you need to give us at least a year. I think there's a difference there that probably is somewhat important.
Okay, that's a good point. I do think, like you said, I think we do need at least to send a notification that here's what's in the works.
I think a copy of what we did in October, actually stating that no new courses are being approved, and that we're giving them a 1-year extension and approval for this particular course when it's corrected. So,
because they're a previously approved vendor.
So maybe if we word the motion that way, I think you might have. So just change it from return the proposal for correction and include the note that this is for, if we approve it, it would only be for a year at a time.
Okay, so my motion.
Because you were a previously approved vendor.
Because they are an approved vendor already.
Yeah.
Right.
Yeah.
Okay. So I'll make the motion that we recommend to the board that because they are already an approved vendor for state-specific ethics courses, we want to return their course material to them for corrections. And upon those corrections, we will allow them a 1-year extension, that their course would be applicable for Tennessee Ethics CPE credit.
I'll second that.
Yes.
Let's have is there any more discussion? If not, then let's have a verbal vote.
Eldridge.
Aye.
Larry Elmore. Gay Moon,
Aye.
Charlene Spiceland,
Aye. That brings us to the last item on the agenda, which is the Tracy Wright reinstatement application.
And this is just mainly an update. If you recall, at the last board meeting, she was supposed to appear in support of her request for reinstatement of a revoked license. She failed to appear. The board initially denied her application, but she contacted us via fax during the meeting. The board then rescinded that decision and voted to allow her to appear at this meeting to answer questions in support of her application. So you have been provided 2 documents. You have been provided her application, which is complete, and probably the document that is more information filled is her complaint history. If you can review that for tomorrow and maybe note any questions that you might have for her in consideration of whether to grant her a license.
Our committee is really not doing anything with this. We're just pushing
I was
this
just wanting to bring you up to date on what was going to happen tomorrow. And we have notified her or reminded her and given her an approximate time to be here tomorrow. We have not heard from her, so I don't have confirmation as to whether she's going to be here or not.
Wendy, just while I'm thinking about this tonight, can you kind of give me? I know you got the timeline here. When was the first? Okay, the first complaint against her, where her license was suspended, was when?
You want the first complaint or the complaint in reference to when her license was revoked?
When it was revoked. So it was a 5-year revocation period. When did that start?
Her license was revoked based upon a failure to abide by the payment plan associated with a complaint from 2006. The date of revocation, that then prompted a new complaint in 2011. She tried to make payments on this new complaint and the old complaint, and then it looks like it was revoked then.
In 2011. So now it's 5 years later.
If you look at the complaint timeline, I mean, it's complicated because the two there in the middle kind of tie into one another. The failure to pay on one caused a new complaint to open, and there are additional charges associated with that.
I guess what I'm getting at, she had a complaint that occurred during her other suspension period.
Correct.
Is that a fair statement?
The dates associated with the complaint numbers or the date the complaint opened is not necessarily the date of disposition. And so that 2006 complaint, the second complaint listed on the timeline, was actually disposed of in 2008, and that's when her license was initially revoked. And then in 2011, she continued to hold herself out as a CPA and had failed to abide by the payment plan associated with the 2006 complaint, and then all these other additional stipulations in the consent order where she agreed that when she applied for reinstatement that she would come before the board, which is unusual. That does not usually occur.
So does she have any outstanding complaints right now that have not been, is she still serving her penalty period for?
Well, a revocation is a revocation. The max time for suspension is 5 years.
5 years, okay. I just was reading. I got confused on all the different things that have occurred. Thanks.
I'd just like to point out in the disciplinary timeline that you have in here, there is, I think, a typo in the next to last complaint that's listed there. It says that the complaint is from the Nashville Zoo. I believe that ought to be Knoxville Zoo. Just for the record.
there any more questions concerning Tracy Wright? Do we have any more business to address in this committee? If not, I'd accept a motion to adjourn. Second.
Second.
Do we need a vote on that verbally? Yeah. We adjourn.
Want to move forward?
Absolutely. I guess we'll start convening the Law and Rules Committee. On the agenda, we show a recap of legislative changes. I don't know if legal's going to do this.
I can do it. Just as a reminder, the law or the legislation passed and was signed by the governor on March 10th of this year, and that included 3 things that we've talked about before. One is the removal of the requirement that the executive director be a certified public accountant. The second item, which we're going to talk more in detail about, is related to sitting for the exam. And the last one is the changes in the peer review requirements, which we will write rules on at a future meeting. So what I'd like to focus on, and I'm going to read you in the public chapter, which is one of your documents, I'm going to read you the part about sitting for the exam, because that's what we're going to have a pretty detailed discussion about today. And the title of the document on your iPads is Public Chapter 0595. And it's Section 2, Number 2. The board may admit to the examination prescribed in subsection D any candidate who has completed a baccalaureate or higher degree conferred by a college or university acceptable to the board. The total educational program to include an accounting concentration or equivalent as determined by board rule to be appropriate. So based on this new legislation, we have been advising students as follows. If a student has a bachelor's degree in accounting, they can be approved to sit for the exam. Now, when I say has received a bachelor's degree, that means it's been conferred. So they have a transcript to provide to NASBA. If they have a bachelor's degree in another discipline, let's say history, and they have enough accounting hours for licensure, that would be 30 hours total with 24 upper division hours, then they can be approved to sit. If they do not have a bachelor's degree of any kind, that we cannot approve them to sit. The last bucket is those folks who have a bachelor's degree in a discipline other than accounting, but they do not have enough hours in accounting for licensure. Those folks are on hold right now in this transition period and are waiting on this board to talk about a potential rule that will define the equivalent of a bachelor's degree in accounting for those folks that have a bachelor's degree in another discipline. So that is my recap. Are there questions before we get into a proposed rule?
Have a proposed rule would be the question I would have. That
I do.
To start the discussion to see what all the bases that we're trying to cover on this.
Okay, on your iPads, the item titled Proposed Rule Accounting Concentration is what you're looking for. Trey, do we want to let everybody read this?
Yeah, why don't we give everybody a second just to take a look? That's not very long.
And I think to keep in mind that that we were trying to make in this whole transition it more fluid for people to sit for the exam during their education process, and this is a gap filler to try to help out a pothole that we made when the law was passed, to try to help fill the gap.
Correct. We intended to make this easier for everybody, but we do have a group of folks that are being adversely affected. I think what I didn't necessarily realize, not that I think it was the wrong thing, but there were a group of folks that were sitting prior to getting a bachelor's degree because they met the requirements under the prior law. And those folks without a bachelor's degree now just can't sit. So that's one kind of bucket, but that's where a lot of people are falling. And also with the prior law, it kind of allowed you to prepare to sit prior to actually having all those things in place. And so now we're requiring that bachelor's degree be conferred and that transcript being moved to NASBA before you can be approved and get your notice to sit.
We're not, does the law, but there are some details here that are not necessarily, that this board is finalizing. For example, we could say, like one of these others, that that they can apply prior to the actual confirmation of the degree. So, for example, a couple of these say you can apply knowing, because there is a period of about 4 or 5 weeks minimum between your application and the notice to sit.
Right. So are you referring to the spreadsheet that has other states' requirements?
And I'm asking because the law is about it pertains to that you must have a baccalaureate degree, but we haven't said at what point can you apply to sit for the exam, and that could be important. For example, if you are going to graduate in May, but you want to go ahead and be able to sit for the exam as soon as your graduation occurs, you would need to be able to apply 5 or 6 weeks early.
Correct. And this is kind of the issue that we have been trying to deal with, because NASBA's procedure, or the way I understand it, is they would prefer you not to apply until you have all of your requirements met. They're not saying you can't apply, but we have a group of students, and we have some representatives in the audience from Vanderbilt and Lipscomb, who have some students who have applied, but they don't have their final transcripts, and we're waiting on those in order to receive their approval and notice to sit. So NASBA can't approve them yet.
But we have already done this for some time, because our certificate of enrollment is what Tennessee right now allows, and that certificate of enrollment is an approval it's a certification from the university that this is going to occur.
Well, the certificate of enrollment was created as a result of the prior law.
Right. I'm just saying that with our prior law, we already had a process in place where they didn't have to prove the hours. So there is a process out there that we have been using.
Well, because the prior law allowed you to sit 200 days before meeting all the requirements or proving those requirements were met.
Mm-hmm.
So it's different. So, so the certificate of enrollment now goes away.
Right. I'm saying, though, that we could utilize that same type of process to allow students to apply so that they would be able to sit as soon as they got their degree. You see what I'm saying? We could use it just like I'm sure these states are doing. They're allowing them to apply for it, because if you have to wait until that degree is conferred, you must then wait the process time for NASBA to take effect, which is 4 to 6 weeks.
Unfortunately, that's not the way the law was written. So these other states that allow for this have it worded that way in their legislation.
Okay. So we can't change that,
So
you're saying?
that's where, correct, we can't
Okay.
change that. At least as far as I understand from legal.
I think there's been much discussion of this over the last several weeks. I think the operative word here is that the board may admit to the examination, and so the law doesn't really contemplate application versus the actual admittance to the exam. So there is a potential that we could we could try to draft a rule. Whether that would pass through the AG's office and the governor's office, I could not tell you. And to address what you're saying is that if we could explain that in rule that we can accept applications with the certificate of enrollment, I believe is what you said, or
Well, something certified, like right now, the certificate of enrollment has to be stamped by the administration, the administrative office that is giving, because students know they are applying at least 6 weeks ahead of time to graduate, usually 2 months. So they know that they're scheduled to graduate. So all the university would be doing is saying, yes, this student is graduating. And therefore, that application testing date could be approved as of this date. And that would at least eliminate, like I said, a 6-week process for the students.
I'm inclined to try something along those lines because I hate to tell somebody they can't sit until they have all the documents in place or apply. I mean,
but particularly for schools that are incorporating, and we have a number of them that are incorporating review classes as part of their program, it really makes sense for the students, to not have to spend. And again, also we have public and private companies that are hiring these students, and if they have the bigger the window they have to be able to actually take that exam, starting as soon as they graduate. But because of this delay, it really can be, it can put a big burden on the students. And it would be a nominal thing because, like I said, all of the universities are accustomed to this certificate of enrollment process already.
It wouldn't allow them to be able to prove them any sooner, though, correct?
It would. Not to sit for the exam. So they still wouldn't be able to sit for the exam until they had graduated, but it would allow them to apply sooner. So because right now they would have to have evidence of their graduation to send in with their application. And what we've been doing in the state of Tennessee is we allow them, if they're within that window, they send evidence of all their courses plus this certificate that's been stamped by the university saying that they can meet these requirements. So all we would be doing is saying 6 weeks ahead of time they put together their application package, and they're still not going to get a notice to sit until they have graduated. And what happens right now in Tennessee, if you apply with that certificate and you don't meet the qualifications, then if you passed a part, it doesn't count. So the onus is still on the person not to break the rule. They wouldn't sit for the exam until they had actually received their confirmation of their graduation. But the fact that they could apply 6 weeks ahead because that application process is extensive, and that would cut off about 6 weeks. That would be very beneficial to the students. So it would still be on them, even if they got the notice to sit early, if they took advantage of it, then their passing wouldn't count. So they have to wait until they get the degree. You see what I'm saying?
So NASBA doesn't approve them until they have the transcript.
Well, NASBA right now, I
understand what the certificate of enrollment allows NASBA to go ahead and prove them. That's the purpose of it now.
It allows them to approve it, assuming that the student is, it's all written out. The student has to meet the requirements that are in that certificate. And right now, the requirements are that within 200 days, they'll have met the degree. But it could be a very similar document that says that they will not sit for the exam until they have graduated. But so they would get the notice to sit, and then it would be up to the student to make sure that they don't schedule that exam until, let's say that they did get the notice to sit May 1st, and they're graduating May 6th. They would not set up their exam until May the 7th.
But we would have to incorporate something in the rule to allow NASBA to approve them on May 1st because they don't have that transcript. They only have a certificate of enrollment.
But they would have a transcript showing everything but the bachelor's degree conferred. Because again, to get that evidence, the university isn't even going to send that evidence out because of just the length of time it takes. They would, if they graduated May 6th, it's not going to be on their transcript for another 2 weeks. And then there's another 6 weeks processing through NASBA. So it's just a long delay when what the law says is that they have to have had they have to have a bachelor's degree. So I'm just saying it shouldn't be any issue at all to change it and make it easier for the students to apply.
I'm fine. I think there's a bifurcated issue. So in the original law, we did have this language with regard to what an accounting concentration for licensure, and that's specified elsewhere within the law and rules. So the first issue with the law change is that this accounting concentration language is repeated not only for licensure, but also for admittance to the examination. And so we have to have a rule which defines what an accounting concentration is for licensure and what an accounting concentration is for admittance to the exam. So that's the first issue. And that's what part of what we have drafted right here.
Right.
The other issue is, again, that this requirement with regards to what you have to have in order to sit for the exam. And that's different now.
Right.
Whereas before, it was within 200 days immediately following the date of examination, you would have all of your educational requirements satisfied. And that's where you get the certificate of enrollment, which would show, hey, this person has all these things within 200 days, they're going to be good to go, they have the 150 hours, the accounting concentration, so forth and so on. But the problem is that the new law specifically states that we may admit to the examination prescribed anyone who has completed a baccalaureate degree, not who will complete a baccalaureate degree, who has completed a baccalaureate degree. That's the issue.
Right, and I understand.
I'm try to write a rule, and also the other issue is that this law change came into effect in between board meetings.
Yeah.
And so we need to get rule language drafted, passed by you guys. Then it goes up through everybody and their mom to get approval.
Yeah.
And depending upon what that rule language says, if we try to expand beyond what the statute permits, it might get kicked down and say, no, the statute is clear. You may only admit those people who have a baccalaureate degree.
But what we're talking about is application, not sitting for the. All I'm addressing is, and again, these other states are liberal in when they can apply. So I'm not talking about sitting.
Well, I understand. We would still need a rule to specify that.
When they can apply.
Correct. And that's what I'm saying is that if our rule says that someone may apply pending their baccalaureate degree being conferred,
that they can apply, yes.
They just can't sit for the exam. That's very clear.
I'm sorry?
You can apply, you just can't sit for the exam until you have that degree.
Right.
There's no reason right now you can't apply. I mean, NASBA's not saying you can't apply.
But see, NASBA won't. So I could send the application as a student, but NASBA's going to sit on it until they get the transcript.
But even with a certificate of enrollment, they're going to sit on it because they can't admit you to the exam.
Well, right now they don't. They approve that certificate and give a notice to sit to the student. So they are giving a notice to sit to the student, but the notice to sit is effective when they're within 200 days. So we could do a notice to sit that would be effective when the baccalaureate degree is conferred.
But we still don't know that when that is until we have the transcript.
Which is true right now. We don't know that the student has met the requirements within the 200 days. But what happens, because the university they don't have a crystal ball. All they're saying is that according to the records of what this student has done, this student is capable of meeting those requirements within 200 days. That's all the university says. If the student sits for the exam and then doesn't complete the hours like they have agreed, then the passing of that part does not count. So it's on the student to make sure they're meeting the requirements. There's nothing. You know, and that's where we are right now based on the current law.
That's actually where we were.
Right.
The
I mean,
current
I'm
law-
sorry. That's
the-
where we
the
were.
current law,
That's where we were.
that is-
Right.
I think maybe
Right.
that's where we're getting hung up. That's no longer law.
I understand.
Yeah,
Hey,
and
I'm just saying that we had that. We have that process. We had that process in place. So I'm not seeing that there's a conflict with the law in terms of the student applying and receiving a notice to sit, as long as they understand that, you know, if they break the law, that anything they do is not going to be approved. It doesn't count.
So isn't receiving your notice to sit your approval to sit? Is that not your approval to sit?
The notice to sit allows them to set a date. That's all. And they have a window to set that date.
But they're issued that because they've met certain requirements,
And
right?
and because a university has conferred or has stated that they are eligible to meet the requirement. So right now, in the past, the confirmation that a university makes does not mean that the student is going to do that. There's no way they can guarantee that the student's going to take these classes that they're supposed to be able to take.
No, but they were following the law by saying, based on the information we have,
Based on the information we have,
they've provided,
they could do
them.
this. They
And
could do this.
The
but
new law says that they can be admitted after receiving a bachelor's degree.
that they can sit for the exam after receiving, not when you say admitted, what do you mean?
Well,
that's the issue. That's you just hit the nail on the head. Is that what does admitted mean?
And that's my point. So if we define admitted as you will not sit for the exam until you have received your bachelor degree, but here 4 weeks ahead of this time, the university is saying that you are going to be able to get your bachelor's degree. And any time after that date, you could sit. We would carve 4 to 6 weeks at least off of their waiting period, maybe even longer.
We agree. We're just saying we don't have a rule in place in order to administer that. And we need to draft. We're in a other world of not having a rule.
Okay, wait. Let's talk. Is legal capable? Can y'all draft us some language to review?
Certainly, and that's the goal. We did have some other language, and I think it kind of got shut down by my superiors. And we're concerned that any language other than what this law has may not pass approval through the Attorney General's office. That's not.
Well, we won't know that though until we submit something, right?
Right, and I agree, and Ms. Weiss and I also agree. That is our goal, is to try to create a rule to try to permit individuals to be accepted and their application approved based upon a certificate of enrollment. We just don't have that right now, and therefore we can't.
I was just trying to clarify that we could do that before we, I just want.
Sure we can.
We're not sure that we can.
No,
We
I
can
mean
do-
the state could, that the board could propose this rule
that's
change.
That's exactly our plan.
That's all I wanted to
It's
ask.
just whether or not it'll get approved. That's
okay.
We'll find out in 6 months or who knows.
Well, I mean,
Can I ask a question?
let me ask you about the time frame of this, because if you start thinking about we're going to draft a rule, we're not going to meet again until what's our next meeting?
July.
So we got to wait until July to approve the language from a board standpoint, and then that's got to go up, or does it get vetted before it comes back to us?
Once it's pre-vetted through legal, we do get it to as final of language as we possibly can get it, that we think it would get approved by the AG's office and the governor's office. It would be brought to you all. You all would vote on it with any particular changes. At that point in time, it would then go through the routing process through a number of offices and could be 6 to 9 months after that before it actually is rule.
And I assume in the meantime, they would have to have a bachelor's degree.
That's correct.
Right.
There'd be a basis for an emergency rule because this is resulting from a law that just went into effect in the last 2 months, or not?
We discussed this, and I was told by other legal folks that no, this didn't fall under those particular.
Did the AG opine on that or not?
No.
I'm not sure it would really matter much at this point, since most students graduate in May. So we're really looking at next year's degree. Although there will be some students that will get their degree in August, but for the
other, maybe I'm getting too far ahead of myself, but the other conversation that we had was if the board came to a conclusion on a particular rule, they could then possibly have another motion to approve me to approve applicants based on
Pending rule.
the pending rule, so that we wouldn't have to wait the 9 months or year to wait till it's effective.
Well, what happens to those students if you're overruled and that?
Yeah.
I mean, if they take the exam, do you come back and say, hey, I'm sorry, those parts you passed aren't valid anymore?
Well, the NASBA's not approving anybody right now. I mean, you have in your documents a list of students that are pending because of these transition issues. And let me find the title of that.
Students pending approval.
Yeah.
I think what Trey's asking is if we agreed to allow you to approve and then the state came back and overruled, kicked it back down, what would happen to those students based on your approval?
It's difficult to state generally what would happen to all of them, I think, with each individual student and how many credits they have and at what stage they are when they take the exam, if they're past 150 hours, some of them may fall, without an actual situation in front of us. I think it's a very difficult question to answer.
Well, but the bottom line is we put those students at risk, and we're putting an undue burden back on them by doing a temporary.
Yeah, I don't think a temporary.
I'm not real comfortable with that.
Yeah, that's too risky, I would say.
The safest road is to abide by the statute as closely as possible, and if they have to wait a few extra weeks, I know that's unfortunate, and no one likes to have to say that, but that's going to be the safest course of action for these students.
Well, I don't want to harm a student from that. So, Gabe, I don't know are you still there, Gabe?
I'm here.
I don't know what your thoughts are from your legal perspective, but I fear putting a student in a situation like that.
I agree completely. Just so I'm clear, I'm sorry, I got lost in the back and forth. So what we're saying we might be able to do through a rule, it's not clear, is to do what exactly?
It is to state that a student who will, at the time of examination, have a bachelor's degree be admitted for examination. So let's just play pretend, and let's play pretend. I'm getting my degree May 6th, tomorrow. But I wanted to apply so that the 4 to 6 weeks times for NASBA to process and give me the notice of examination so that I may sit, I don't know, July 1? Is that right? July 1.
Well, let's say you wanted to sit May 10th, and that's very common because the window ends at the end of May. So you have a real crunch of people trying to sit for the exam in May. And if they're having to start the process after the degree is conferred and the transcript shows it, they can't even start the application process until probably May 20th.
So the issues with NASBA, it sounds like the issue is, am I overstating this? NASBA is the one that's interpreting Tennessee law and saying we're not going to approve anybody and give them a notice to sit until you give us this information?
Well, we are trying to advise them on how to follow the law the way it is now.
It looks like
a way where we can approve.
Well, just like the statute is drafted for 15 years ago, and I sat for the exam when you did it twice a year, is what it looks like, and that hadn't changed. I guess it's not technically out of date because it says at least 2 times a year. But it seems like if we're set up as the gatekeeper, as who actually goes into the testing center and takes the exam, and I don't know in practice if that's actually what happens.
It is. NASBA will do whatever we tell them to do.
Right. So I'm just saying, I think from what I was taking from Charlene's comments was that there's a 2-step process. One, NASBA says, yep, here you go. You're ready to go. It's so long as you complete what we gave you your prospective approval on. But then for that to work, somebody has to be in the back end saying, yep, you did in fact actually graduate and you got your degree conferred on this date. And so it seems like the way the statute, even though it's antiquated, is like we're the ones that are supposed to play that second role to actually say, okay, you applied on April the 1st, NASBA gave you your notice to sit, we then required you to show us, or the school to show us, that the degree was actually conferred on the 6th of May, so you can sit from May to 10th. But it sounds like we don't do that right now.
NASBA actually also does that if that's necessary. And they will continue to do it for us. They may change their fee structure, but they are willing to continue to do that.
And they would do it anyway, Gabe, because regardless of what we do here, there's still a delayed process that has to be approved, which is that they meet the 150 hours. So regardless, their NASBA has to come back in, and that student has to send evidence of the hours.
But not for sitting for the exam, but for getting the certificate.
Right. And what I'm saying is that we shouldn't, beyond the fact that they get a nose to sit, if they don't follow the right process in the back end process, they wouldn't get that credit for passing the exam if they haven't received their baccalaureate. Do you see what I'm saying? Because there is a back end check process anyway in place, regardless.
Yeah, I think the point that Ben's making is that the way the statutes, we can't let them actually into the testing center to take the test unless we know that a degree's been conferred on them. That's what your point is. And so I'm wondering, I mean, if we're really concerned about doing it quickly, it seems like we could, I don't know, I mean, I'm not the one that's advising this, you and your folks are, but it seems like we could figure out a way to do a rule that would work with the law to make it clear as what they're doing, but also maybe renegotiate the contract if we have one with NASBA to say, we also need you to come back, and before these people are allowed to be checked in, I don't know how they do that, I'm assuming they go in and show an ID or something, before they're checked into the system, make sure that we've gotten confirmation from the university that a degree was conferred on them, and put the onus on the student that they really want to do this and apply in April so they can sit at the end of May, even though they just graduated at the beginning of May, to make them get the transcript and send it in somehow to show the conferring of the degree. It seems like we did that.
But they may not have the ability because the university may not process that quickly.
I mean, it was a long time ago, but the day after I graduated, I went to the registrar and got my final transcript with the stamp on it. Is that not the case anymore?
Well, right now, the student can't send that in. It has to come from the university. If you take, I mean, you know, the student can't send anything. It has to be directly from the university to NASBA to make sure that it's all valid.
Or we could choose to have the student get it in a sealed envelope with a stamp or the signature across it and send it to our staff to let them look at it, right? I mean, if we wanted to do that.
Even in that instance, we're still talking, if I graduate tomorrow, I don't know. I mean, I don't know how quickly registrar's offices work now. I couldn't tell you. My guess is it might take a week to 2 weeks before they get everybody sorted out with all the final grades.
And they've already, the booking, the end of May books up 4 weeks ahead of time. So by putting in that process, we essentially take away the ability for them to sit for the exam sooner rather than later.
I don't think so. I mean, that's not what I'm thinking. What I'm thinking is we're actually allowing them to do that because the point is they can't be admitted to the facility to take the exam and actually see the exam until we know they've got a degree. And so we're trying to figure out, is there a way we can short circuit the delay between the school sending it to NASBA and NASBA getting it keyed and then sent back to the right testing facility or whatever? Is there a way to short circuit that so that they can apply in April, graduate on May the 6th, and show up on May the 10th with the transcript in their hand that says they've been conferred a diploma and sit for the exam? Because absent that, I mean, the statute's pretty clear. They can't be admitted to take the exam. So I don't know if we have a desire to do something like that, but if we really thought it was a big deal and we had staff resources to dedicate to it, that's one thing I guess potentially we could do, because it looks like the way the statute's drafted, the General Assembly is looking for us, the board, to be the final gatekeeper to say, yep, you graduated, you can go in and take your exam. I know in practice that's not how it's set up, but that's what that's how the statute's drafted.
Could I ask a question? The old law, the 200 days before meeting the educational requirements, that referred to the 150 hours, did it not?
Right.
And the current law has reduced that, it seems to me, by saying all you got to have is a baccalaureate degree to be able to sit for the exam. So really, you're under current law, you're going to be able to sit for it quicker than you could under old law. Is that not correct?
Not entirely, because the old law was 200 days within the date of the examination. So, if 200 days immediately following the date of examination. So, if I was taking the exam on May 30th, so long as I had all 150 hours, should have all 150 hours, 200 days after that, May 31st, 200 days, we're talking January something, then you could sit for the exam. But that means they can accept your application now in April upon showing it. But now, if I don't get my degree, my baccalaureate degree, until May 6th, I can't even apply because I can't prove that I have a baccalaureate degree until after the conferring of that degree.
Yeah, but it still seems to me the new law that most students are going to be able to sit for the exam quicker than they could under old law.
I'm hopeful that's the case. Of course, we're not hearing from the people who are excited. We're only hearing from the people who are having problems. So I don't know. I'm hoping it's helping more than it's hurting. And I've heard from at least 2 professors that they feel like it is. So I think what I didn't realize is how many people were attempting to sit before even having a baccalaureate degree. And so my traditional thought was you get a baccalaureate degree and then you got to go another year before you get your 150 hours. So this actually gives you an additional 5 or 6 months with the new law. But there are this group of students who have 140 hours who've never gotten a bachelor's degree and thought they were going to be able to sit and can't. And so that's where we're.
Well, the bottom line is those students we can't help anyways, because it's going to be 9 months before we get this thing resolved.
Right. There's nothing we're going to do that's going to speed up the process for anyone who has the issue right now.
Well,
the people that are in the queue right now, we can't do anything for them.
Unless you want to create some back-end process that we probably don't have the staff to do, to actually fulfill the actual language of the law, which is to sit there at the door of the testing center and say, yes, you're admitted, no, you're not. Yes, you're admitted, no, you're not. Practically, it may not work, but I mean, that is the one option that we could do without having to do a rule. I mean, at least I see it. That's Ben's call, but that's the way I see it.
I mean, I would agree with you. But I think facilitating that might be very difficult.
Because they don't sit in the same room all the time anymore. We're both the old school.
Right.
In more ways than one.
Yeah, like when you graduated in May and had to sit for the exam in November, you had plenty of time to get it together.
We've got some educators with us that we would certainly welcome input. You all hear the direct comments. If we're missing something or you want to have input, please join us at the microphone and give us your thoughts on this, if you would like to. Edmund said you'd hold up his end of the bargain.
My name is Brian Masterson. I'm chair of the Accounting, Finance, and Economics Department at Lipscomb, and I'll kind of give you our fact pattern from a Lipscomb perspective, one of which would add to Wendy's, I think, 4 that you already mentioned. We have students who already have a degree, but it was not a degree in accounting, and they're looking to do a Master's of Accountancy program so they can then be eligible to sit for the CPA exam. And so we've had students who've already applied and have been rejected. So we've got 2 student populations that have applied and been rejected by NASBA. The first is that student population who has a degree, albeit say in management or economics, but they're coming to get another 30 plus hours of accounting to the Master's of Accountancy program, but because they don't have enough accounting hours, as of their December transcript, they were rejected. Then the question is going to be, well, that student, as of whatever transcript we're able to get for them in May, they may have 24 hours and they're going to take another 6 hours in the summer, and they'll end up graduating from the Master's of Accountancy program in August. We still like for that student population, the one who has a degree but is pursuing a Master's of Accountancy, we'd still like for them to be approved before August, which is when the actual Master's of Accountancy would be approved. And so when Wendy was describing the current explanation with respect to that student population of saying you need to have 30 hours of accounting, well, that basically is taking that student population and pushing them even further back than they would have been clearly under the prior law. And so that's something that has me a little bit concerned in terms of what the board is going to be doing with that population. The second student population that has already been rejected are those students we've already talked about. And they are students who do not have a bachelor's degree yet, but they have more than 24 hours of accounting. In fact, many of them will have 30 hours of accounting by the end of school. In fact, our graduation is on Saturday. And the reason they were rejected was because they did not have a bachelor's degree at the precise time that they applied. And so we're working with Wendy and working with Alan to make sure that those students hopefully do no harm with respect to them. But the issue with respect to why students have so many hours, Lipscomb I think was a little bit different than most institutions in the sense that we had a joint program, a joint baccalaureate and Master's of Accountancy program. So you would go to Lipscomb and within 5 years, you would not get your bachelor's degree until the end of the 5th year. And on the same day, you would be awarded both your bachelor's degree and your master's degree at the same time. And we did that so that scholarships and financial aid could carry over for that student population. And it was something that helped them pay for their Master's of Accountancy program. And so when we first learned about the change in law, we knew that immediately we would have to decouple our joint program. And so we've taken steps administratively at Lipscomb to do so. And we have identified 6 students. So I don't know if all 6 have shown up on your list of 40, but we've identified 6 students who were joint students at the beginning of the semester, but now they're no longer joint students and they're all expecting to graduate on Saturday with their bachelor's degree. And then they'll come back again in December and graduate with their Master's of Accountancy degree. But that student population is the one that would have had 140 plus hours at the undergrad level, because they've not officially transitioned to the master's program. They would have had probably 30 plus hours of accounting as well. And they were all, when they started the master's program in January, we gave them a calendar that said, you're going to start sitting for whichever part we set up first. You're going to start sitting in July, you're going to sit for another part in August, and we give them the schedule. And then all that changed on March 10th. And so we've now gone through this process of decoupling the program, and students are looking to us for guidance. We're looking to Wendy for guidance. And right now we're in a state of lack of clarity. And so whenever the rejection letters start coming through, then the students are a little bit alarmed at that point, especially when initially some of the rejection letters were saying, oh, you've been rejected and you'll have to repay the application fee again. And that's been handled, at least to my understanding. That part's been handled. The students will not have to pay a second application fee, those who've been denied. But at any rate, we've identified 6 students who were in that first population. In terms of the joint program, we've identified an additional 2 students who are in the Master's of Accountancy population, but already have a bachelor's degree, albeit not in accounting. And I don't know if all 8 students are on your spreadsheet or not. But anyway, this is certainly an issue for our students and something that I know I get questions about on a daily basis. And so anything you guys could do to provide some degree of clarity and leniency to the extent that you think is permitted under the statute, that would be much appreciated.
This solution that Charlene has covered in the, like the certificate of enrollment used to work,
right,
would that alleviate most of the problem that we didn't anticipate was going to be there when the law was drafted?
I think on a going forward basis, from the way our program works, I actually think the law will be helpful. And we've told Wendy that I think going forward, and even when I was having discussions with representatives of the TSCPA, when I first saw the language, I said, I think going forward, this will be very helpful for students in terms of when they can sit. But I said, we're going to have a transitional issue that we're going to have to deal with. And now that's what we're dealing with. And the certificate of enrollment form may work very well in the interim. I don't think that's the permanent solution, but at least in the interim, I think it works. The reason for our students, I don't think it's necessary is because our students would not be sitting in May. So if a student graduates in May, our students are not looking to sit in May. Our students are not looking to sit until sometime in the fall. Vanderbilt may have a different view on that given their schedule.
Oh, let me ask a question on the other side, the other issue, which is how many accounting hours. I know because that's the other part of this law. This proposed rule speaks of 18 hours for accounting. And I don't. It doesn't say whether those 18 accounting hours are upper level, because obviously the concern might be that we're including financial and managerial to get to the 18. And it also says something about internship, which I don't think. So from an educator viewpoint, my concern is that we might be giving a message out to students that there isn't any more accounting required to pass the CPA exam than these 18 hours. And if that's the case, then what, after they take financial and managerial accounting, what 4 courses are they going to take that's going to allow them to pass the CPA exam? So where do you feel?
Here's what we're
there?
advising students, and Wendy and I have had a conversation about this. At Lipscomb, we have a program called the Certificate in Accountancy Program, and it's something that appeals to the student population who has a degree. They're looking to transition into accounting, but they're not looking to make the financial investment that's necessary for a master's of accountancy. Certificate of Accounting is a much lower price program, and we have students. In fact, one of the student who just I think scored one of the highest scores in the state of Tennessee went through this certificate program and chose not to go through the full-on master's program, but they're still getting their 30 hours of accounting. The issue with 18 is all about when a student can start sitting, because what we do is we advise students very carefully on, based upon the courses they have taken thus far, okay, maybe you're in better position because you've had Intermediate 1 and 2 and maybe another advanced financial statement analysis type course. Maybe you're best suited to take FAR first. And then as you're continuing your studies, you may be, taking audit, and then we would say, okay, after you've done audit, which may be your 21st hour, then you sit for audit, and you may take tax next, which would be your 24th hour. We stagger it with our students. We just want all of our student populations, including the certificate program, to be able to sit as quickly as they are ready. And we are telling students, we certainly counsel students not to sit if they are not ready.
And about how many are in that program? Because that's not that's obviously, there are not a lot of people who come back in that. So how many
It's
are in your
interesting, based upon
certificate?
our numbers, that program's actually about the same size as our undergraduate traditional accounting program,
Which
roughly
is
75 students each. In fact,
75.
our certificate program is actually beginning to slightly outpace. I think the number was 78 this year. So it's actually a decent sized population from our accounting student perspective.
Do you have any in that program that have done internships and get internship credit before?
No, typically we advise them not to do an internship, because in most cases they are full-time employees somewhere else, and they're taking these courses at night. And so typically they do not want an internship because they can't do an internship given that they are fully employed. In fact, I just reviewed an internship report for one student from the certificate program who was looking to transition, was not employed, did an internship for academic credit, and her perspective was, this was phenomenal because this is exactly what I was wanting to do. I was wanting to transition. But I would say that is clearly the minority with that certificate population.
So as it's written right now, with his at least 18 semester hours at upper division level, without including the internship, it would still meet what you're currently
the
doing.
18 hours includes financial and managerial. So it would be financial managerial, and then we would have another 12 to get to a total of 18. Even our traditional program, so the traditional Lipscomb student who is 21, 22 years old and they're majoring in accounting, they are only graduating with 21 hours. And theirs is 18 hours plus 3-hour internship for 21 total hours of accounting. And that student moves into our Master's of Accountancy program.
But prior to this, they had to get their master's anyway, basically,
Correct.
to sit. So you can see my concern is that because most of the students sitting for exams, are not non-traditional. They've followed a career, 4 years, and they're looking to us to say, well, this is the knowledge base you need to be able to pass the exam. And so, again, my concern is that if we are not giving them that message that you need to at least take X number of hours, then they're going to be students who are going to think that they could pass the exam with, because we're supposed to be we're supposed to be assisting them.
Understood. The only thing I would say with respect to the hours, if it's north of 21 total hours, which includes the 3 hours of internship, then we have to go back and amend our current undergraduate program. Otherwise, we're left in the same spot that we would be here, in the sense that if we have an undergrad who, under Lipscomb's current program, say they graduate in May, they're looking to start the Master of Accountancy program in August. If it's a 24-hour requirement, that student would not be eligible to sit or to even apply under the current construct until sometime after their fall semester is over, because that's when that third hour, that 22nd, 23rd, and 24th hour, would actually be credited on their transcript. And so that student would actually be basically back to where we were under the 200-day rule, which was you can start sitting in January if you're graduating in August.
But you've already amended your program right now.
We've amended it we've decoupled it, but from an undergrad perspective, it is still 18 hours of accounting courses plus a 3-hour internship for a total of 21 accounting hours at the undergrad level. The difference between our degree program and our certificate program is the certificate program does not have an internship requirement. You still have the same 18 hours. You just don't have 18 hours of technical accounting, substantive accounting. You just don't have an internship. And then those students who are in the certificate program, they move into a graduate certificate program, which is a 12-hour program. So that's how you get to the 30, if I'm just pursuing certificates.
So would 21 hours total, without regard to whether it's upper or lower division work? Did we have this conversation?
Yeah.
It would work for you, right?
It would work for them, but the question is, does that really work for the students? Is that the message that we want to publicly state, that you only need, and because essentially it would be, again, this way, it's if we don't have that upper level in there, it's financial and managerial and 4 classes. And if we count any internship, that takes away from the knowledge base that they actually need for the exam.
Take out the internship part.
Yeah, so if you had it and eliminated the internship, because 30 hours certainly count the internship. But I mean, that's my feelings.
How many hours does a Memphis student have when they get a bachelor's degree?
They have 30 hours, and in fact, in the current we just passed, they have to have 36. So by the time they graduate, there isn't any need for a master's, and that's the other dilemma. So I mean, as far as I'm concerned, all of the universities and colleges of Tennessee need to readdress, because many of them changed their whole program based on the fact that they assumed everyone would go get a master's, and they were encouraging them to. We just passed a law that takes the focus off of that completely. Now, students are going to look to get hired as soon as they have their bachelor's degree. And firms are going to want to do that. And so now what's going to happen is a lot of emphasis is probably going to move over to online programs where they could go on and get a MBA or a Master's of Accounting online and be working, because it's certainly easier to do that while you're working than it is to study and pass the CPA exam while you're working.
Are the schools giving academic credit for prep courses for the exam now?
Some are, and that's all over the United States it's occurring. So that, again, in terms of the 30 hours. So some states have addressed it by saying you must take these 6 different classes, and not talked about the number of hours, and then meet 30 hours of accounting, so that they didn't really care. And again, a review course could be looked at different ways, but if it's in a university that's accredited, they've had to put some pretty stiff stipulations in terms of exams and everything that goes with it. So 30 hours is a lot of accounting, but 24 is, I think, pretty much all the knowledge base of accounting that you need to take the CPA exam.
Lipscomb if you are a bachelor's holder going into the master's program, the 21 hours you have, does that include, you said it includes 3 hours of internship, is that right?
1 3-semester hour internship.
And then, so the 18 that are coursework, are any of those, is any of that credit for doing a prep course for the exam?
There wouldn't be any way to do a prep course for the exam if you haven't had enough accounting classes. You know, a prep course only isn't, you know, it does take some, like you could maybe skip advanced accounting and cover that in a prep course, but you've got to have audit, tax, intermediate 1, intermediate 2, cost. I mean, there's a list of courses that you really need to take in school. And again, by not stating that, there are a lot of universities that assumed the bulk of these courses were going to be taken in their master's program. And so now they need to address, because we don't want our students, I don't believe, to have an undergrad degree and believe that they can go pass this exam with just that. And if we say all you need is, you know, 4 courses in upper level accounting to go take the CPA exam, there's an insinuation that they could pass the exam with that. And I've been doing this long enough to know that isn't possible.
So, question: so the current, or maybe their old rules, it's 01-0.05 on the applications piece. Subsection 2 says that the application isn't going to be considered final until all of the coursework has been certified as complete. So prior to this law change, like, so let's say last year, the big back and forth that y'all had a while ago about certificates of enrollment or whatever, it seems like you still would have run into the same issue, that when you apply to NASBA prior to having a degree conferred on you, that you still wouldn't have been able to be given a notice to sit for the exam, because according to our rule number 2, the document there's no certification, there's no documentation saying that you've completed all of the education requirements. There's a document that says you're on track to, and you likely will absent some disaster, but it doesn't say that you have completed it.
Which is exactly what my point was, that in the prior rule, we had already allowed them to send in a certificate of enrollment saying that they were going to, and there was no certification completing that they had.
So all I'm saying is that likely didn't comport with our rule that was in place at the time. So, I mean, maybe that's not my decision to make, but because the way I read it, it says that you have to have transcripts and proof that the education or the candidate has satisfied the education requirement. So I'm just wondering if there's something obviously somebody looked at that and thought it was okay. So is there some way we can make a similar opinion based on the new law change?
Can you tell me that rule number again? I'm sorry.
It's 0020-01-0.05. Uh, 0020-01-0.05, and it's section 2.
That does not mention the 120 hours or the 200.
It just talks about the completeness of an application, which I thought meant you applying to get a notice to sit.
What you're saying is that the previous procedure did not comport with this particular rule, and
or we thought that it did somehow, and however we did, could we apply that to the current situation? Yeah, this isn't about education as much as it's just about when an application is considered complete. So I'm assuming that means the application with NASBA that you can sit for the exam is complete, and you have to pay the fee, you have to submit the application, and you also have to provide transcripts and proof that you've completed the education requirement, whatever that is, whether it's the old education requirement or now the current education requirement.
Yeah, but if you'll give me a minute, yeah, it's in section 62. C1.
right? So it says, so C1 talks about how you can't get your certificate until you've completed the hours, right?
They admit to the examination prescribed in D, any candidate will complete.
That's how you got right at that. I got you. So we can't use that same thing.
Right. An official transcript doesn't necessarily show that there's been a degree conferred. It could be an official transcript 6 months before a degree is conferred. It's just the official transcript showing what classes this person's taken and what classes they are currently enrolled in.
Right, and the certificate of enrollment went that step further and said, here's what they're going to take to complete. But the certificate of enrollment could say, and the degree will be conferred May 6th. You know what I'm saying?
Yeah, so it'd be nice if they would, if for something, like if it was me and I decided to go out and party and I failed my final and I didn't pass, if they would then send a letter that said, the certificate of enrollment is null, and that way the person that gets it for the exam.
Well, right now, they could illegally in the past, they could have illegally sat for the exam and then it was taken away from them because they didn't meet the.
I think, but Ben's point is that we had leeway there, and now the leeway seems to be taken away. Yeah.
We can keep the process rolling here, and get covered. We've got, have you got anything else that you'd like to add to it? I know you do.
Because we're a little bit different too than Lipscomb's nuances. But the Vanderbilt MAC program, our mission is to bring new people into the profession. So virtually none of our students have undergraduate degrees in accounting. They're in anything from economics to art history. And part of our one-year program is our students graduate in May. So this year it's May 13th, and then start studying and sitting for the exam the following week. So this has impacted them. Right now, they don't have notices to schedule at all. And they're in this pending holding. So I have instructors and classrooms and everything set up to go, but no exam date. In the future, if there is an hour requirement, then I would ask that the hour requirement is after our third mod. So it's before they finish their studies. And at that point, one program would have 23 accounting hours, but to your point, 6 of them, this is assuming that the 6 hours would be internship, and 6 hours would be financial and managerial, because that's what they come in with. They finish the rest. They have a heavy fourth mod, and that covers, they get through the accounting coursework. So that's one thing. I also want to make sure that as you all are defining the rules, you don't make it so that it is understood that they have to have some type of degree in accounting, because then that will definitely harm virtually all of my students in that aspect. So I want you to please be mindful that is happening. And just to put some perspective around it, we have very successful students. We have the past 2 years have seen over 90% first time pass rate on sections passed. So they are successful. They want to be in the profession, and right now they're being blocked. And I know that wasn't the intent of what the intent of the law was, but it is adversely affecting my students this year. And I hope that it doesn't going forward.
How can it be? How do you suggest that going forward, hearing what you've heard on the constraints that we've got on us, we're trying to find the solution.
Yeah. So going forward, if the accounting hours were this is assuming that it moves to 6 hours for internship, which I understand there's some issues there, but when our students come back from their internships, they have 23 accounting hours. 17 of them are upper division. They're upper level. And the other, that's our valuation program. Our assurance program comes back from their internships with 29 hours, and 23 of them are upper level. But that does include the internship.
Oh, yeah, I was going to say, the internship counts as
I
an
did
upper
count
level
the
accounting.
internship when I was looking at the curriculum.
What do you think about the application process?
If my students could apply before they get their master's degree, and then sit after they receive their master's degree in accounting, because at that point they have 30 hours. They're qualified.
They could, the way it's proposed, they would be able to sit with a bachelor's degree. So there's
My
no,
students don't have an undergraduate accounting bachelor's degree, which is what it says.
No, it does not.
It's any bachelor's degree.
Okay.
Yeah.
The total educational program to include an accounting concentration or equivalent. And so the issue that I think I mentioned before is that that's language that was borrowed from the old statute. The problem is that we're having the same standard for applications for examination and for licensure. Right. At the time of licensure, I think we can all agree that we have it pretty clearly how many hours they have to have, and that's an accounting concentration. The issue is that we don't have a definition for what an accounting concentration is for sitting for the examination, which would be less.
Right. So that's what we're looking at, is whether that accounting concentration is 18 hours of upper level, whether it includes internship. But I'm in complete agreement with you on the not having them have, because we have many students who come back and don't have an accounting undergrad. So I don't think that's in debate here.
But our students do apply. So to your point, if they were able to apply for the exam in March to sit in May, that they would need that extra March to May to finish the hours to get to an hour requirement, unless you were saying it was 23 accounting hours with 17 of them being upper level. That's what would fit our program, and that would include internship hours.
Just a quick question. I mean, if they're allowed to sit and it is confirmed that they have, finished their degree, and I mean, chances are, the process would rule them out. If they don't have enough accounting background, they're probably not going to pass those particular parts.
That's true.
So,
but I know these students, and what I'm trying to say is,
you don't want to break their
You'd
heart.
love to tell them you don't have enough knowledge to pass. You'd love to tell them, but it's extremely expensive, and all of them they believe that they're capable because they don't understand.
Right. Okay.
And so I think we do the injustice by saying, well, yes, all you need, and that's not to say that there aren't exceptions out there. There are always exceptions, people who have enough business background that they don't need all the account. There are people who could probably study the material on their own and never have a credit. That's all possible. But when we tell them that all you need is that, because most of the students who are going out there and taking the exam are they're young and they don't understand. And so they're going to spend all this money and fail. If we say you only need 4 accounting classes in upper division. And that's, to me, the message we're giving. And I think it's very little to ask the universities to simply tweak your courses and, tweak your degree and add in another accounting class here or there as part of your undergrad. That's because they all changed it when we changed the law however many years ago, so that those students would go into a master's.
I'll say this, and I see your point, because a traditional student would be a 4-1 student or 150 hours. But I don't have room in our curriculum to add another course because it is a fast-paced year. So I don't have room to add another course before they apply for the exam in March to stick with our program and being able to sit throughout the summer. Right now, our students are supposed to sit at the end of May, beginning of June, but they may not be able to because there's no way for them to sit because they don't qualify, although they have a very high pass rate. So
are you just talking about the max students who don't have an undergraduate business or accounting education?
yes, I have 31 students this year. I think 5 of them have received their notice to schedule. The rest do not have any accounting or business undergrad. Next year I'll have 45 to 50 students. And I think at this point we have 4 that are undergraduate accounting majors.
I just want to be clear, though, the point you're making is that if you have too high of an hour requirement to sit or to apply, then the people that are going to be affected are those who came to accounting late in life or whatever, late in their educational life, and they're now MAC students with no prior accounting. Is it right?
And if there was a once they have their master's degree, it doesn't matter because the coursework is built into that to qualify for their license. So that wouldn't be affected. So if they can apply before they're actually qualified and before they get their degree conferred, then then that would help my students, and that would be fine as long as they can get their as long as they get their notice to schedule at that time so that they can it takes 4 weeks out to get that scheduled. So I'd just like for you all to consider that. Any other questions about?
Thank you. Then it appears the biggest thing that could be accomplished is looking at this proposal here and adding a proposal that we try to find a way to allow them to fill the paperwork out and have it recognized in conjunction with the rules as they are, with agreement with NASBA. That, I mean, obviously they can't sit for the exam until they've got the baccalaureate, but at least we could have the pipe filled up and let them try like we did in the past. Because we made the change to make it easier, and nobody saw this, pitfall.
Okay, so maybe can we focus on the number of hours and whether they should include internship hours? And then I think the best we can do is attempt to work on wording that we feel like would work for the application process.
In the meantime, can NASBA go ahead with this list of people we've got in this thought process and get them approved, subject to, instead of just stonewall?
No, because they have to have if they
get the degree the next week,
graduated,
then all the paperwork's already been turned in.
Then they're
well,
fine.
If you look at, I have some buckets here of people. There's some people that need an April transcript. They should be fine. They should be able to get that in. The people in the third section are mainly those are people who do not have an accounting degree. They're waiting on this proposed rule that will define it less than 30 hours. That's what that group's waiting on.
So to that question, if we approve some wording on the hours, is that also still a 8-9 month delay, or?
If we look at this proposed rule and the board votes on it today, we can go ahead and start that process, and at earliest, 6 months.
Oh, at earliest.
And they can't go back to the 200-day thing either, right?
That's the legislature, so no. I mean,
No.
if the legislature, if they so choose to do that next year, then that's that. No, we're talking March or April of next year.
So who can sit for the exam at this moment?
Those individuals that have a bachelor's degree in accounting, and have it conferred. Those individuals who have a bachelor's degree in something else and they've met the 24 hours, those are the folks that can sit.
Okay.
I'm sorry. This is an hour ago, so I'm forgetting. The issue that came to light is that students that were about to graduate were applying and they were rejected. So can we not focus on the fact that admit means actually go to the exam? I mean, admit doesn't have anything to do with applying. And so could we not tell NASBA to approve all those applications?
Well, but that's, I think, as you know in your line of work as well, I think reasonable people could disagree as to what admit means. I don't necessarily know that the legislature intended admit to mean allow them to walk into the door versus stamp of approval, you can sign up for an exam.
I think, yeah, I mean, they could differ, but I think it's reasonable to read it to say you're talking about maybe not admitting you into the door, but actually taking the exam. I mean, admit to the exam means actually sitting and taking the exam. It certainly doesn't mean applying to take the exam. I mean, I think nobody could make an argument that admit to take the exam means you're making an application to take the exam, right?
Yes, sir. And I will tell you that some of the previous language that we had drafted and run up through my supervisors was to state, I don't actually have it with me because I stopped using it, was to define baccalaureate degree or the equivalent. So what it was going to be is saying, well, you can have 120 hours. That's what we're going to say. That's what you need for entrance into it. And my supervisor said, well, that's actually not what the statute says. We can operate within the statutes. We can't change what the statutes say.
Right. So what I'm saying is, instead of focusing on that, which I think was a good college try, was to shift the focus to the word admit. Look at what admit means in the
Absolutely.
dictionary, and it certainly doesn't mean apply. You know, I mean, is that an option? I don't know. It's not my call.
I mean, NASBA's never said you can't apply, but when they issue that notice to sit, is that when you're defining admit or when they walk in the door to take?
I would think admit means when they sit down to take the exam on the computer, right?
Yes, I think it's vague at best.
I agree, but I just wonder if it's an ambiguity that.
And that was what my proposal was, is that we could draft some rules and explain that admit means the date that they are sitting for the exam, and therefore an application could be considered complete, and they may then they may pick a date to sit for the exam once we receive a certificate of enrollment, and on that date of the exam they will have had a bachelor's degree conferred.
I agree that clarity obviously is what we want. I guess my question is, if that was the option that we thought we had to do, does that then mean that we believe not defining admit that way by default means that it means applying for the exam? Because if that's the case, then I'm not sure the rule is necessary for us to approve the applications early. Because nobody's going to, I mean, the plain meaning of the word admit to take the exam does not mean to send an application to NASBA and get a notice to sit for the exam, right?
So then does NASBA, when they do a notice to sit, do they, within that, they give you what date you can start to sit?
No, so NASBA, when they give you the notice to sit, you can sit at any time. And so they were considering, or they do consider, an application complete when everything's been checked off. So we'd have to have, the student would have to provide some evidence from the university saying that student was going to have a degree before, because there has to be that one other piece for NASBA to say, okay, and yes, they're going to have a degree.
Is there an opportunity for us to send a letter to these people and say that the board is conditionally admitting you to take the exam based on this notice to sit, provided that you do the following, and it's get a degree conferred before the date you sit for the exam, so that if they don't do that and they go sit for the exam, then it's just null?
Well, that's what happens. That's what happened in the past. We didn't have to send a letter. The law stated, the rules were also detailed. And again, if they sat for the exam and then didn't meet their 200-day limit, then the credit didn't count.
But I think we would have to do it now, because it's saying that the onus is on the board to admit them and make sure that they're properly qualified. So if we're talking about trying to do something for 1 year as a stopgap, which maybe is too late, could we draft a letter to the handfuls of people that are caught in the situation saying that, yeah, you've got your notice to sit, but you're hereby on notice that if you don't graduate and get the degree conferred prior to the date you sit, that it's not going to count?
Possibly. I think it's probably above my level to make that call. I also think, going back to that rule with regard to applications, as to what a completed application, I don't think under the current statutory law that an application is considered until, even if it's a transcript reflecting they have a bachelor's degree.
So you're saying like NASBA can send the notice to sit until the transcript came in based on that rule?
That's, yeah.
Okay. Valid point. Tried, guys. Sorry.
And I think most of these people that are in limbo now, because their degree date is for a number of these is May. I think the bigger problem is that we have to define this accounting concentration. And even if we define the accounting concentration, it's going to take 6 months to go into effect. So essentially, these people have to get 30 hours of accounting and a bachelor's degree, or wait 8 months. or however long it takes for this to be through the process. And in all fairness, most of them were already doing that, because if they were getting a notice, as it stood, they had to have a certificate of enrollment saying they were going to get the 30 hours within 200 days. So they were all going to be able, if they were actually in the process and about to sit for the exam, they should have been qualified by August anyway. So nothing we're going to do is really going to affect the list of people. I don't think.
I would agree. It sounds like there's not much, especially the center bucket, we're going to be able to do. And so if we can just focus on what the rule will be going forward.
Right.
I was hopeful that once you all approved a rule, that you could then give me authority to act in accordance with that prospective rule. I think it would be safer if it just included hours and not this, or equivalent, where we would use the certificate of enrollment type thing. That's where we feel like it would get caught up with the Attorney General. But if we, I don't know what the risk is there about you all allowing me to approve folks based on a prospective rule.
Do we have a proposed rule for the clarifying of what the admit means, or just about the accounting concentration?
Just about the accounting concentration. We did not tackle the admit. Initially,
it's too risky.
I'm sorry, Trey?
I said it'd be too risky to do the admit piece, wouldn't it?
Yeah, I mean, I feel that way, but I'm not the attorney. I said it'd be too risky to work with the admit.
No. It's not. It's not too risky. It's more risky. It's just more difficult. We don't know if the AG's office or not is going to come back and say, "Hey, no, it's clear they have to have a bachelor's degree."
But the thing is, I don't want to give Wendy latitude to go tell people one thing and then have that not be the case 6 months from now.
Yes, sir, I understand. I think what Wendy was asking, if she could have the authority based upon the proposed rule with regard to what an accounting concentration is, not what admit is.
Yeah, Trey, I was just saying, I mean, if we don't deal with it, it's going to happen this time next year. So if we need 8 to 9 months, is it worth it?
Well, is it? Because I thought that the whole point of what we just heard wasn't that people are going to be able to actually sit earlier, right? I mean, did I misunderstand that earlier? That in most cases, this is actually better for people trying to take the exam on the admit piece.
Trey,
it's just that we've got this limbo group right now that I'm afraid we can't do anything for.
I think that based on the two educators we just heard from, that next May, they're going to be in the same situation, at least with respect to the undergrads who haven't gotten their degree conferred yet, but want to sit for an exam at the end of May.
Because they're not accounting graduates, right?
No, I mean, they would have, from what I heard, they would have some level of accounting concentration. I don't know, but the hours weren't consistent across the programs, but they would be graduating like the first part of May.
Well, but you're talking about the concentration piece, right?
No, I'm talking about the admit. I'm just wondering if we should try to also get the admit rule drafted so it can be in place before next May is all I'm asking.
Okay.
Not necessarily to do it
with
and have Wendy act on it now, but just do it for next year.
Okay. If it's something we need to address, then let's address it. So what do we need to do on the concentration piece? Do we need to come up with a number? I mean, what are we trying to do?
Yes, I think I had proposed 18 hours upper division, and I had included not more than 6 hours of internship hours, but that was mainly just because it was in the other part of our, so I totally see if that needs to be eliminated. And I've heard from various professors, and 18 hours upper division, I've heard anything from 21. I think UT would prefer 21 hours. Several other are fine with 24 overall hours. it sounds like the 18 upper division could be problematic for some. So I
Charlene,
think
do you have a recommendation?
My recommendation would be 18 hours upper division, not counting internship. I believe that that is a fair statement, and if someone comes in that's not an accounting major, they need to take 3 hours or 6 hours outside of that concentrated program. But I think that it's a better message to give our students because they're not going to be able to pass the CPA exam without 18 upper level division classes.
That's 6 classes on a 3-hour schedule, or 3 hours apiece. That's 6
Right.
classes. So 2 intermediates
it
and
would
4
meet
advanced.
the requirement of 24
Yeah.
hours, which is what most undergrad programs have, not counting internship. Because again, the internship tends to be more of something you would do for your 30 hours. You don't need the internship. The internship isn't necessarily going to help you pass the exam, but these core courses are critical for the exam. That's my recommendation.
I understand. I have one question though. The CPA exam is very different today than it was when I took it, in that you had to do it all at once, twice a year. And because the students, do they typically do all of them? I mean, the staff in our office concentrate on a part kind of each quarter. So I'm wondering if that gives us some leeway in the number of hours, because as Dr. Masterson suggested, you're not sitting for a specific part until you're really ready for it. So does that give us?
But they
some,
still have an 18-month window, and so that's the other part that they're forgetting. And the exam is about to get much more difficult. So if anything, by us not holding to this, the test that's coming out next in a year involves a lot more higher level knowledge base. And so we really would prefer, and the whole reason they changed the exam was to say that we need students who think much more outside, more analytically, more mature. And so we want to hold to that message, I believe.
Am I hearing that as a motion?
Oh, well, I'm not on the committee.
Oh, you're not on the committee.
I can't make that
Who's on the
motion.
committee, Wendy?
Trey, Gay, Charlene, you are on the
Oh, I
committee.
am on the committee?
Yeah. Janet and Gabe.
Well, now
Charlene, do you have a motion?
I have a motion. My motion would be that we define accounting concentration to be at least 18 semester hours of accounting education at upper division level, junior level courses or higher.
For the purposes of examination.
For the purpose of the examination.
And
okay.
Not permit
The
internship hours.
internship would not be included in those 18 hours, but could be included in the 30 hours that are required.
I will redraft that last sentence to indicate that.
You can do what with that last sentence?
I missed that.
The last sentence on the proposed rule states that internship hours can be allowed, but no more than 6 or 8. But the amendment on the floor currently is
to remove that from it.
The entire rule as it is, scratch that, and actually probably state that internship hours will not be permitted to count
for those 18
I do
hours.
think you need to state that.
Yes.
But would count towards the 30 hours. So we want to make sure.
I'll get it.
Okay, I have a motion on the floor. Do I have a second?
I second.
Okay, any discussion?
I just have one question on what's in this draft. It says 27 quarter hours of accounting education at the upper division level, junior level courses or higher. What does that mean? Is it upper level or not?
It is upper level. I added the junior level or higher because that's how it's used in other parts of our rules.
Oh, are we going to exclude that junior level courses?
No, it's the same. So junior level or higher. That's just how we define. basically what it means is that these are classes that cannot be taken in a 2-year college. So that's why it says junior level in our law.
Like junior in college, so a 300 level or above.
Right.
Is
Exactly.
and the only reason I use that is because it was used
In
that way
there,
elsewhere.
it is, and it may be old, but it's still understood in universities.
And we have not been accepting 2-year courses as community college courses as upper division.
Okay, is there any further discussion? Do we need to do a roll call vote, Wendy?
Yes.
Okay.
Janet Booker Davis.
Aye.
Gay Moon.
Aye.
Gabe Roberts.
Aye.
Charlene Spiceland.
Aye.
Trey Watkins.
Aye. Now, do we need to do anything other on the other issue, or are you just going to draft us a rule and we're going to look at that the next time?
We will draft a rule with regard to what admit means, try to clarify that, see if we can't get something with the certificate of enrollment for the July meeting.
Okay.
Is there any possibility, and I know you aren't going to have any spare time between now and tomorrow, and it may be a moot point since we're already into the May, but I'm still really concerned about this list that we've got and how to handle them, and if there's some way we can get a clarification that allows us to at least get them to process those returns, those applications, to where they're ready to go as soon as they get the transcript.
So if the board tomorrow approves this proposed rule, is there any appetite for, and legal help me out, on authorizing me to go ahead and admit folks based on that prospective rule?
For the accounting concentration only.
Correct.
I think on that front, I would think we're okay. I mean, would y'all see it differently? I don't know. Legal.
I agree.
I think so. I think we can. I think if you make the motion and I find out from my supervisors that we can't, then at least we've made the motion. It's about as best we can go, I think.
A motion?
Make a motion that we allow Wendy Garvin to approve the accounting those students who have met the accounting concentration as defined by the state board tomorrow.
Okay. So we have a motion. Do we have a second?
A second.
That's a recommendation to the board tomorrow.
Right.
Correct.
Any discussion? All those in favor, I guess we'll do roll call vote.
Janet Booker Davis.
Aye.
Gay Moon.
Aye.
Gabe Roberts.
Aye.
Charlene Spiceland.
Aye.
Trey Watkins.
Aye.
Is there a way then on the drafting of the other rule for the admit piece to somehow maybe use Charlene to get the schools to give us? I mean, I know we have a formal comment period when we do a rule, but it'd be nice to get them on the front end so we can understand what their various concerns are about that piece, to make sure we're actually addressing the issue.
Application.
On the application part, seeing what the admit is. I mean, the two that we're speaking today were extremely helpful to me to understand what the issues are at the schools, and it'd be nice to kind of make sure we're doing something that's actually going to fix a problem,
I think most of the information that they gave us today is with regard to what their individual programs were and how many hours they're going to have in accounting. I mean, if we can craft a rule and get it passed that we can accept a certificate of enrollment for someone to apply and approve that application for them to sit for the exam once they have a bachelor's degree, that should cover everybody, I would think.
I know when I was looking at the different states, I'm sure that I saw one of the states that does this. So maybe the question should go to NASBA. What does that state do? How do they verify? Because their rules said that they had to have a bachelor's degree, but they could apply prior to the bachelor's degree.
In my research, Charlene, I found some states that do that, but it is in their legislation. So
It states in the law.
It states in the law
that they could apply early.
And so that's where we run into problems, is that it was not in our legislation that way. And so you're absolutely correct. There are, have requirements, but you may apply prior to or within 120 days of or something of that nature. But everything I found, it's a manual process. So I did about 8 states.
Yeah, and it may not have been detailed in some of because it may not be as visible for you to be able to see, because as you said, it was manual. You're looking for the wording.
Right. So I went to NASBA first, and they give you general information. Then you have to track it back to the law and rule itself and find out exactly what it says. And so I was looking for avenues in which we could do this, and I just couldn't find anything, because there are states that do it. It just happens to be in their legislation.
Okay.
Trey, I think everyone will be happy to note that the third item, we do not have anything for you on that item. So
that's good news. I take a motion that we adjourn. Law and Rules is adjourned.
We're going to take a quick break here, and we've got law or whatever.
Executive Committee is next.
Next, okay. Let's take a quick stretch break and bathroom break or whatever, and then Executive Committee. Wendy, are we still good with the Executive Committee
items to discuss?
Right.
Yes.
Okay. Would you like to bring us up to date on the financial results, please?
I will. You have a couple of documents. You have FY16 year-to-date financial results, and then you have a variance sheet. And you have the FY16 budget as your second column on the financial results. And then we have year-to-date actuals of where we are as of March of this year. And happy to report that we're doing well so far. Revenue is running about 2% less than the prior year. However, this was expected due to the fact that we're not collecting convenience fees and credit card processing fees any longer. So we're in line with where we need to be there. On the salaries line item, with the release of one of the investigators, we are trending a little less than budget here. Longevity, we are exceeding budget in this area. This is, I think, only one of 2 areas where we are exceeding budget. The raises that the state provided the investigators back in January were not applied to their salaries, but were given in a lump sum and fell under longevity rather than the salaries line item. So I'll note that as we budget going forward. Typically, the state does that when your salary range is outside of, when your salary is outside of the range, from my understanding. Travel's been relatively modest. However, you'll see an increase in June. We've got 4 board members attending the NASBA Eastern Regional meeting. So I still think we'll come under budget, but we will see an uptick there in June. Communications and shipping, we have incurred most of our expense in that line item for the current year. Third-party professional services, the only thing to note here is we have seen an increase in credit card processing fees. We just have more people renewing online, and so we're going to see a greater expense there. We'll also see some expenses due to the formal hearing tomorrow that will fall into that category. Supplies and furniture, our supply needs have been really low so far this year, so we're doing really well there. Rentals and insurance. Previously, this item included the rental of our copier, and that has been moved to computer-related items, so we're not seeing any expense in that particular line item this year. The computer-related items, this is the other line item where you're seeing an increase over last year, and that's because we've moved that copier rental there. And state professional services, trending less than budget there with the elimination of a leased car and the convenience fee that we had to pay for, or the expense that we had to pay for previously. And year-end costbacks, average monthly costbacks are trending around $24,000. So the last column of your results there is a very conservative projection, I think, for our fiscal year end of June 30. As you'll note at the bottom, that would get put to $18,000 into reserves. I think we'll end up doing better than that in the end, but again, this is a conservative projection. And that's my
Thank you.
report.
Have you got any questions, Wendy, in the financial report?
I want to ask, the state regulatory fee, do we just record that at the end of the year, or?
Yes, it's on June 30.
Yeah.
Yes, and it's based on number of licensees.
I wonder why we wouldn't accrue for that like other items. I mean, it's like costbacks or anything else. I mean, it's not a big deal, but it just looks strange that you've got a budget for the year and nothing in an interim basis.
Yeah, I can certainly ask. You know, they just started giving us a sense of what the costbacks were going to be each month, where we didn't know that until the end of the year previously. And I've also asked for them to, if possible, for them to break that out, the costbacks, so we can get an idea of, you know, what's legal expense, what's admin expense, etc. So.
Let's see. I don't know that we have anything to approve on that. It's just informational. Travel information.
Travel information is very minor this month. You'll find under travel report, Don's travel-related expenses for this particular quarter, or for the third quarter of the fiscal year, and my travel-related expenses, which consisted of the NASB Executive Directors Conference.
Questions? Okay. Executive Director's position.
This is just a kind of an update on what's going to happen tomorrow. The legislation passed that allowed the Executive Director to be a non-CPA, so we have been told that you will need to ratify my position if you choose to do so. So that will happen first thing tomorrow.
The CGMA designation, we will not make a career out of this discussion, by the way.
I'll try not to. This is simply to bring the board's attention some of the concerns raised in this area. As many of you are aware, the AICPA approved offering the CGMA designation to non-CPAs last fall. Prior to that, I believe CPAs could attain that designation. Now non-CPAs can do that. And one of the concerns has been about the use of that particular designation and how whether our laws and rules allow for the use of that designation. And so Chartered Global Management Accountant has the word accountant in it. And as many of you know, we've had this conversation in the past, and the use of the word accountant when you are not a CPA is generally prohibited. So this isn't the first designation that presents this problem, but it's brought it to light, I guess. So the CMA designation has been around for years. We haven't necessarily, you know, I haven't seen complaints on something of that nature. So the issue isn't necessarily isolated to the CGMA designation, but it is a concern. Many boards across the country are very concerned about the use of that designation in their states. So I wanted to just make sure the board understood those concerns from a national perspective.
And I think from legal, would you speak to that? And that I think in some of the preliminary work we got back, I believe you actually the one that spoke to it and said it was a prohibited usage.
Yes, sir. The statute is certainly, as written right now, would continue to prohibit that designation.
Does that mean
by a non-CPA?
On CPA, so it's an education thing going forward. If you get that, you can't use it in Tennessee unless you're a CPA.
I mean, yes, sir. The way the statute's written, I think we had a pretty extensive conversation about this back in October of last year. It would still fall into that prohibited area.
Question, Gabe? Okay. What about the evolution of peer review?
Okay, a few months ago, the AICPA proposed some changes in the administration of the peer review program. Right now, the peer review program is administered by 40-some administering entities across the country. Generally, each state has their own administrator. The society administers that program, which is how we do it in Tennessee. The TSCPA administers the peer review program. The proposal to increase efficiency and effectiveness of the program by the AICPA is that they reduce the number of administering entities to 8 to 10 of those administering entities. So they released this discussion paper a couple of months ago for comment, and just want to get some feedback from interested parties on any concerns that there might be there. I know some boards are concerned because of their oversight function, and if their state no longer administers the peer review program, having to oversight that process in another state or by the AICPA if it comes down to that. I don't know exactly the decision of the TSCPA, that they're probably not in a position to be one of the 8 to 10. So it's very likely that our firms will end up going somewhere else to have their peer reviews administered. And for some boards, I understand that's been some concern over that. So I just want to make sure you all were aware of this. If you wanted to discuss it, you could certainly comment. We could prepare comments if you felt that necessary.
Know if that'll be covered at the Eastern Regionals?
I believe so.
Because I think from a personal standpoint, and I'm sure you have a personal interest in it as well, I'm not sure there's any states that did any better than what we do it, and I would have serious concerns of us turning that over to somebody else.
And they would only pick 8 to 10 states who are doing it now to do them all.
Correct. And those states would generally, I guess, at the beginning opt in, and they have to meet certain criteria. Basically, they would have to staff up to make sure that they could administer at least 1,000 peer reviews a year. And so there's some requirements they would have to meet. And just for reference, the TSCPA administers about 275 a year right now.
Got to staff up.
This is the AICPA's program. It's not the Tennessee State Board of Accountancy program. It's not the Tennessee Society of CPA's program. It's the AICPA's peer review program. And quite frankly, they're free to do set the rules as they want to. Now, this board is free to accept them or not accept them. If you declare that the AICPA peer review program is not the program of choice, and you're faced with the alternative of either doing one yourself or going somewhere else and selecting a better one. I think their objective is to try to bring consistency and high quality. And quite frankly, with 41 administering entities, some have fallen short. The Department of Labor has issued their report on some issues that some reviews are having. But bottom line is, Tennessee, we can be very proud of our peer review program. We're, I think, one of the 3 to 5 best of those 41 administering entities, and I'm proud to say that on the record. I think the AICPA would tell you that, and quite frankly, it's due in large part to Wendy Garvin and Kara Fitzgerald, in addition to Roger Johnson, Art Sparks, and a wealth of talent we have from our volunteer leaders. We have some 25 CPAs on the acceptance bodies that spend an awful lot of volunteer hours working on this program, and it's administered very consistently at a very high quality. We've never had any issues in Tennessee. That being said, the AICPA's objective is to try to consolidate states so that you have regional administering entities, which will probably be the larger states. Wendy mentioned 8 to 10. I quite frankly think it's going to take 2 to 3 years at the very least to transition this program. And at the end of the day, we're probably looking at 3 or 4 or 5 of the larger states, maybe Texas, New York, California, potentially. AICPA will probably be administering a good number of them out of their Raleigh office. But at the end of the day, I'm speculating it's probably going to be 4 or 5 administering entities at most, with a minimum of 3,000. So we would just not have the firms to administer right now, unless we went out and recruited, Alabama, Mississippi, Louisiana, and others to turn their programs over to us, and we would hire more full-time technical reviewers, more full-time staff to process the reviews, and then we would rely on volunteers, which are stretched thin right now, in getting that program, keeping that program's quality where it is presently.
41 state societies doing it now.
There are 41 state CPA societies doing it now. There are a handful, 6 or 8, that Arizona allows California to do theirs. Delaware allows Pennsylvania, I think Vermont.
Ask what those that are not doing it themselves, they just contract with another one.
Yes, we would have the option of partnering with another state to do that. I see this consolidation of administering entities as still relying on Tennessee acceptance bodies, i.e. volunteers, to participate in that process. I know that a number of your firms are highly engaged there. Bob Weatherly, for one, with your firm, he is very engaged in that process, and I see him being utilized by whatever administering entity we select in Tennessee. That's speculation. I think the whole purpose now is just to bring this board up to speed. Some state board of accountancy has expressed concern over it, but my advice would be let's monitor the situation over the next year. It's going to take at least 2, probably 3 years for them to transition this thing, if that's their objective. It's out in exposure right now. We can comment on our concern over some of the issues that state boards have proper oversight of the program, but at this point, comment should be just that. I don't know that we should make any decisions to select another peer review program.
What would happen? I mean, if that happened and your theory is right, and like maybe the Southeast goes through the Raleigh office, do the states in the Southeast and have to pay or enter a contract with the Raleigh office in order for that to work, or what?
No, the Raleigh office would be charging the firms participating in the program an administering fee like we do now. We operate this on a net loss, if you will. we run a small deficit. The objective is to try to get the program to break even. Firms pay a modest fee on an annual basis for administering expenses, and whoever administers it would just be charging the firms. It wouldn't cost this board or anything, as I see it. The board doesn't pay anything now. They just designate that peer review program as a qualifying peer review program. And it's really up to this board to make sure it meets the qualifications that you deem to be prudent. And that's been the case going forward. It's clearly raised the bar on the audit quality over the years since its inception. And it's a good thing. It's in the statute. But this board has the opportunity to choose the program. Back 5 years ago, this board had its own small program for some 100 firms that did not belong to the AICPA's program. Typically, they were offering lower level attest services, but and then you have SEC firms that are in a separate program that are approved by the board. Wendy's much more knowledgeable about the overall program than I am. She spent 10 years administering it, but we're very fortunate to have someone on the board staff that understands how the program works, all the potential for flaw, the changes that are occurring, and I would defer to Wendy and Kara for insight on what's the right thing to do. But my point here is that I don't think anything's going to happen overnight. We just need to maintain and manage and monitor it right now.
Anything further? Thank you. That concludes the executive committee. Next committee. No, it's officially adjourned. So.
Okay. Let's go ahead and get into the enforcement committee, and the first item on the agenda is review of the complaint statistics. And I believe in your library you have a report called Complaint Statistics, and I want to open that up. And we did welcome any comments you or Don might have on this, but when I looked at it, looks good. We had 58 complaints opened and 84 complaints closed, so we are certainly making progress on reducing our caseload. I guess I had a question. Administrative complaints are 44.8% of our total, and practice complaints are 55.2%. And I wonder if you could tell us how we define those, or what criteria we use for classifying. I would think the administrative are the things like the CPE and so forth that are opened by the board versus some issue to do with negligence or fraud or just malpractice that might be a complaint driven by someone outside the office. But
I think you're on track. I generally have been classifying it based on something that I need technical expertise would be a practice complaint.
Yeah.
An administrative complaint would be like unlicensed practice or failure to meet CPE requirements or failure to respond to a CPE audit or some other item. So the other items would fall under practice complaints, where we would generally need Don's assistance in vetting that.
Normally we have gotten a report of how many cases we actually have in process. Is that, am I missing that, or do we just?
I just haven't done that. Mainly, I think Don used to prepare that, and we just started getting, when we went live with our new platform in September of last year, we quit getting any reporting. And so we have been kind of doing it manually to try to keep up with everything. And we just started getting our reporting a couple of weeks ago, and we're trying to get through that and make sure everything matches, and not everything matches yet. And so we've been working through that. So I did not prepare a report, but we will do that next time.
All right.
Mr. Stewart.
Yes.
I can tell you currently on our are a few errors and some omissions. So aside from those, we have 48
Does anybody have any questions or comments on the report as it's presented? Okay, I think the second item on the agenda is a staff recommendations for letters of caution. And Wendy, I assume this is something you might want to comment on. You've actually got a letter in here, I believe, that
Yes.
drafted. What is the name of that?
Right. So
Yeah,
I
letter.
have staff recommendations for letter of caution, and then I actually have a sample letter of caution letter that would go to these folks. So what Ben and I have found is that we have a certain group of folks who are self-reporting discipline in another state. It's not revocation, it's not suspension. It's generally a minor, either a reprimand or a minor civil penalty that have handled. And it's something we'd like to keep on the record, but we didn't feel like opening a complaint was necessarily the right thing to do. And so my recommendation is to bring these to you each meeting, explain where similar to a legal report, we have a number for each one, where they were disciplined, and the nature of the discipline was not suspension or revocation, and request a letter of caution be sent. And then I provided a draft of what I would send upon your approval of those. And so otherwise, we either need to open a complaint and do investigation ourselves on something that's already occurred, or we don't do anything and we can't keep it as part of the record, is the way I understand it.
And if I can elaborate, this stems from I'm now representing an additional board. I know you're all very sad to hear that, but this board, it's the Architects and Engineers Board. Individuals will be disciplined in another state if it's anything below a suspension and it does not involve work done in Tennessee or a Tennessee consumer or any real ties to Tennessee. They will open a complaint, but it will never become a case to legal. And basically it's a way to take these materials, save these materials, assign a number to them, but administratively, in essence, close them, of course, pending the board's approval. And there's one of two ways that we can do this. One, Wendy and her staff can come up with a letters of caution report in which all those cases are on that, or we could just add an additional section onto my legal report. It's 6 one way, half a dozen the other, but really it's instances, and I'll give you an example. There's a gentleman who is a Tennessee licensee. He is also licensed in Florida and about 5 or 6 other states. His Florida firm doing work in Florida, and it was an audit, did not have a firm permit when they issued an audit. So whether or not that's a good item for us to investigate or not and then subsequently discipline, we don't feel that it is, I think. And there's a lot of other boards that do this, especially when we were in Nazareth, we learned boards did it there, and the A&E board does it. It's a way to track this, and so we have it associated with their license that this occurred, and we have it. But because nothing really occurred here in Tennessee, although the person held a Tennessee license, not really much to discipline.
What would you have us do today? Are you wanting us to approve the process or approve this draft of the letter, or what do we need to do to let you do what you think you need to do?
Approve the process in the letter.
Any more discussion on this or questions? I mean, I wouldn't.
Really, you don't really need, we wouldn't necessarily need to approve the process because it would still go through the entry level of opening a complaint just like anything else does, and we already know that works well, but just that we would handle these kinds of cases in this fashion.
I'd make a motion that we recommend to the board tomorrow to follow this process.
Okay. Second that motion. Okay.
Have anyone left on the phone?
Yes, I'm still here, Stephen.
Are you on this committee, Stephen?
No, I'm not.
So do we need to?
Janet Booker Davis.
Aye.
Larry Elmore.
Aye.
Gabe Roberts.
Aye.
Don Royston.
Aye.
Casey Stewart.
Aye. Okay, is there anything else, Wendy, on that subject matter? Okay. The last thing on the agenda is the legal report, and everybody should have gotten a copy of that, I believe, before the meeting. There are a total of 34 individual cases on here. They've been grouped by basically recommended action of legal counsel, but the first 10 cases are recommendations for closure. I have read through these. They all seem extremely straightforward, and really I didn't have any questions. I would ask if anybody on the committee would like to discuss any specific case, or if you have any questions. If not, I would entertain a motion that we approve the recommendation of legal counsel on the cases numbered 1 through 10.
So moved.
Okay, we got a motion and a second. Okay. Do we need a roll call vote, or is it just?
Yeah, I believe the roll call vote is not only for our benefit, but also for the individuals listening.
Okay. All right.
Janet Booker Davis.
Aye.
Larry Elmore.
Aye.
Gabe Roberts.
Aye.
Don Royston.
Aye.
Casey Stewart.
Aye. Okay, case number 11 is a case where we've recommended a letter of information. This is a complaint where the respondent has a complaint for lack of due professional care and the performance of services. It's a situation where the complainant contracted with the respondent to manage various financial aspects of the complainant's joint medical practice, but there were financial problems, I think significant losses, unpaid bank debt. I think the investigators made numerous and used various methods attempting to contact the complainant, but really couldn't obtain any supplemental affidavits or documentation and so forth. And basically neither party produced any substantive documentation that would prove or disprove the allegations. I think the respondent did have some issues with some payroll matters and offered to basically amend some payroll tax returns and refund some amount for expense and penalties. But legal counsel is recommending that we close the complaint just upon the issuance of a letter of information. So anything else that legal counsel would like to add?
The letter was just to indicate that some of these things could be avoided in any situation using an engagement letter with the client.
I guess we need a motion to approve legal counsel's recommended disposition here.
So moved.
Second?
Second.
Okay, let's have a roll call vote again.
Janet Booker Davis.
Aye.
Larry Elmore.
Aye.
Gabe Roberts.
Aye.
Don Royston.
Aye.
Casey Stewart.
Aye. Okay, the next 4 cases are recommendations for letters of warning, and I will cover these a little bit individually. Case number 12, basically the respondent self-reported a disciplinary action that was taken against him from the Securities and Exchange Commission. It centered around his firm using a consultant who had basically been banned from practice before the SEC. The respondent apparently reached a settlement with the SEC and agreed not to practice before the SEC for a period of 3 years. The respondent was licensed also in Nevada and Georgia, and this happened to be involved with a client in Nevada. As a result of the SEC discipline, the respondent's business collapsed. Our investigator noted that based upon the documentation that the respondent provided, that the audit work was certainly deficient. So, again, the recommendation is to close the complaint upon the issuance of a letter of warning. Any questions or comments, thoughts on that individual case? We'll vote on all 4 of these together if not. Case number 13, the complaint against the respondent was for using prohibited language in his firm name, indicating more than one CPA was on staff when there was not, and that he used the designation CPA without being a registered firm. Basically provided extensive documentation of actions he had taken to rectify the situation, including changing the business name of the Secretary of State and on its letterhead and website, and also submitting a firm permit application. And the respondent now holds a Tennessee firm permit and has no other history of disciplinary action. Again, it's recommended to be closed upon the issuance of a letter of warning. Any comments or questions on that one? Number 14, the complaint against the respondent was for using a prohibited title or designation on his profile on the firm website. Respondent basically replied indicating he was unaware of the laws and rules. He's now provided documentation of actions taken to rectify the situation, including changing the title and designation on his website. This particular respondent does not hold a Tennessee CPA license and has no prior history of disciplinary action. Just a thought here, he's not really holding himself out as a practicing accounting then.
Not holding himself out as a certified public accountant, but I believe it was a tax accountant, or I might have just said staff accountant. It's one of those two. Tax accountant.
Recommendation is closed upon the issuance of a letter of warning. Any questions or comments on this case?
So this was not a person who had a Tennessee license?
That's correct.
So why are we even involved?
Because using the word accountant or holding yourself out as an accountant, according to the 62-1-113, is prohibited. And this ties back to the memorandum that we provided you guys back in October of last year about the use of the word accountant. And this is in line with what we had discussed there and what the board decided how to approach these cases.
Questions? Okay, the last case, number 15, in this one, the respondent was not, the complaint alleges that the respondent was not properly enrolled in a peer review program despite offering audit, review, and compilation services. The respondent replied stating that it does offer attestation services and that it does hold a valid firm permit, but it does not actually provide any attestation services. And the respondent further asserts that this information is only on the website for marketing purposes. So I think this is a situation where he's saying we offer these services, but they're not really doing any of them. So because they're not actually performing the services, they don't have to be enrolled in a peer review program.
And that's actually comports with the rules and the law. I felt it was walking right up that line of misleading advertising because it appears they offer the services. So anybody who looks at it would say, oh, well, they do these. But if anybody were to ask them to do that, they would say, oh, no, we don't actually do those. But they are registered as a firm. And we scoured the laws and rules and cannot find that it's an actual violation. However, there is a rule pertaining to firm advertising, and I felt like this is walking right up to that line of misleading, and I felt like a letter of warning was most appropriate.
Given the right opportunity that comes up, they could decide to do those services and then enroll in the peer review program at that point.
They should, before they contract to do those services, they should enroll in peer review. Otherwise, that would also be a violation.
How long does it take to enroll in peer review?
A few days. It's a pretty quick process.
Is the firm permit issued or tied to? I mean, this smacks to me of the ridiculousness that we are here to stop, right? I mean, so this is a competitive advantage over every other firm out there who tries to be a good actor and that doesn't offer attest services and that doesn't, put out there that they do them. And I mean, if I'm a business owner trying to make rational decisions and I'm going to make, an irrational decision, in my opinion, to do this, the idea would be that I'm going to bring the clients in, and then the transaction cost for the client to go somewhere else is too much, and so they'll just stick around, even if it means they have to go somewhere else for an test engagement. And maybe that's wrong, but this seems to me like this is crazy. And all we're doing is we're sending a message to everybody else that doesn't enroll in peer review and that doesn't offer these services to do this exact same thing. And then you've got a confusion of the public issue, which again is what we're here to do. And so it seems to me like if there's any way we could tie this to something else to do more than just a letter of warning, I would be all for that. This to me this is ridiculous.
I battled with this one for a while and read over it and hunted on the rules, and I really, I hate to say, was hoping to find a rule that they were in direct violation of. I think perhaps this would be
on the firm permits. Are they not? And I don't know how this works, but are they not specifically tied to the owners themselves who also have licenses? And would that not be a tie-in to the moral character of a licensee?
Not necessarily. I mean, you have to be a CPA in order to be a manager of a firm, and in order to even own a firm, you're going to have whether or not how many partners you have, and if the person who's tied to the actual firm permit is the person that, I mean, maybe.
Seems to me it's worth investigating because I mean this is I'm sorry, but this is ridiculous. I don't know how y'all feel. I'm not the practitioner, but if I were in your shoes, I would not be happy, especially if you made the decision not to offer a test services, not to enroll in peer review, only for your competitor across the street to say, oh yeah, we offer it, why don't you come here, get them in, and then all of a sudden they've got an unfair advantage from a business standpoint. In my opinion, I think this is the exact kind of stuff that, I mean, if we lose the peer review, right, with the coordination of the peer review, and then we don't take action on this, then I guess my question is, what do we do as a body, as a governing body, other than issue the CPA certificates?
I mean, I understand what you're saying, Gabe, but it sounds like the law doesn't give us a lot of room to reach out and get this guy here, but also from a business standpoint, he's probably trying to leave the door open. I mean, he could decide on a moment's notice to actually perform those services. But at that point, he's got to enroll in a peer review. I mean, he's just saying, I don't have to be enrolled in peer review because I haven't done any of them yet.
But what about that issue that came up before, that he enrolls in peer review and does one engagement and decides this isn't for me and then backs out and never actually has the peer review? I mean, isn't that also a potential harm that the public gets?
Yeah. Yes. I mean, we have attempted to, when they enroll in the program, and make better notes about when they enrolled and when they claim that they were doing a test work. And if they then try to get out, we go back and require them to have a peer review if they didn't.
I assume this letter of warning could comment on that aspect of it that
we believe it's misleading. Yes.
Well, not just misleading, but that should he decide to actually perform those services in the future, he needs to understand he would need to be, maybe we attach a copy of the peer review requirements for him.
I'm not on the committee. I'm sorry, and this just kind of struck a nerve with me too. But is this not just fraud? I mean, you're holding yourself out saying you offer something but you don't do it. I don't know what the consumer protection laws say about that, but it's almost like, bait and switch. Come on in, we got it, and then we get there, you don't.
The issue is that the way the laws are written and the way our rules are written, there's some discrepancies, and so some of the rules say that in order to perform, you have to have a firm, you have to be enrolled in peer review. It doesn't say in order to offer, you have to be enrolled in peer review, but it does say if you want to offer or perform, you have to have a firm permit. So technically, according to our law and rules, he's fine, although it does strike a little bit of a misleading nerve. However, if someone came to him tomorrow and said, to this firm tomorrow, and said, I really like you guys, I really like you doing a test engagement, and he says, okay, let me get enrolled in peer review, and as soon as I'm enrolled in that, then I'll do it, then I don't think that's fraud.
All right, what about the competency standards that he's equipped to do that engagement?
Yes, sir. And,
before he has to have the training before he engages in it.
Correct, but I don't think that we could. I think we'd have to wait until he were to engage in a test engagement and then we could challenge his competency.
And the harm is done, though.
Karen, help me there. When you file for a firm permit and you want to provide a test work, you have to provide experience in the attest field, correct? So I don't know if we do or we don't have that for this particular individual, but we could certainly go back and find out whether when this firm applied, whether they had that experience or not.
And if you remember, I think we talked about this in probably some July and October of last year. Individuals who had no intention of offering, but they wanted to use CP in their name, and so they had to get a firm permit, or they just wanted to say that we are a registered firm. And I know that the board had some complications, some questions with that, but there isn't really anything prohibiting these folks from doing that. Is in that same area, I think.
I think it's in that same area, but the distinction I would draw is that there's no harm to the public in having someone who's not required to have a firm permit get a firm permit. In fact, you could argue that there's benefit to the public, to their clients. In this situation, it seems to me like there is zero benefit to the public, and potentially some harm. I'm not saying there is, but potentially some harm, either from an actual transactional cost piece of thinking you're getting something like Stephen said, but then you get there and you're not, or maybe a client doesn't understand the intricacies of the peer review piece, and so the firm says, "Yes, sure, we'll do your engagement and give us 2 days to get the engagement letter signed," and then scurries around and signs up for the peer review piece. But to the client, does the client think, well, if they're offering it, that means they do it and have a competency in doing it and have been peer reviewed and have done? And I'm not the first person they've actually done this for. And I mean, look, I'm the first person to say that if we don't have, if they found a loophole, then good for them. But we can't go retroactively and get them. But we need to try to address this, in my opinion, in some type of rule change or law change, or see if we can, if it's within our purview to do that.
We're going to have to rewrite the peer review rules anyway, based on the legislative change in peer review. So, I mean, if we can certainly, if the board wishes to try to incorporate something that requires them to be enrolled if they're offering these services, we could certainly try to do that. You can be enrolled in the program even if you don't provide the services. So you could enroll as what they call a no A&A firm, and you would continue in that status, and each year you would be asked to verify that you haven't done any work, or if you've picked something up, you would notify them and you would have a peer review.
It seems to me that that's a little price to pay for the privilege of being able to offer the fact that you do a service. That's my opinion. I'm not the practitioner, so y'all have a different view, but that's just my opinion.
Well, I mean, I think it seems appropriate. If you're going to offer the service, then you should be in the program. On the application for either the CPA or the firm, I know you have to answer some questions about whether you do attest services. I'm not sure if the questions also relate to, do you offer them?
And do you remember exactly what it says on the application for a test? Okay.
Because if it asks, do you offer the services, then
I think it says, do you provide?
Yeah, I can't remember whether.
But
yeah.
we'll let her verify.
Okay, any further comments or questions on that case? Okay, we will note your take some notes and follow up on that. Okay, would entertain a motion that we approve the recommended disposition of cases 12 through 15.
Moved.
A second.
Janet Booker Davis.
So did we want to make an exception for number 15?
I didn't understand the exception. I think it's something to address the comments that I mean, there's really not anything else we can do with 15, is there, at the present time? The law is what it is.
I think we can
Question.
check to, I mean, I don't know if it makes a difference if we check to see if they had the experience when they got their firm permit to provide a test services. Does that make
If my memory serves me correctly, in the case file, I had the application for the firm permit, and it just says, "Do you provide? Do you provide?" If you say no, then you don't have to put what your experience is.
Which sounds like a problem. It leads back to what Gabe's saying.
The application asks for the services the firm plans to perform, and then notes that if your office performs the test services, you must have a peer review performed once every 3 years.
Also asked to list each CPA who is responsible for, supervising the test services and signs or authorizes someone to sign the accountant's report on the financial statements on behalf. And so I guess that would be the tie into the experience, is who here is actually doing these pieces.
You said it says if you plan to provide. So Casey, to your point, I mean, if you were going to put it out there to say, well, if somebody comes in the door with a big enough price tag, then I'll subject myself to that. That seems to me like you're planning to provide it under that scenario. And if under that scenario, if they said no, then it seems to me like they're violating their application. Now, maybe that the legal counsel decides whether that's a good enough attachment. But
substantially, I agree with what you said, but I can sit here today and say I don't plan to provide that, to be part of that, unless a real good opportunity comes along.
Well, and so my response is then you update your application and enroll in peer review. I mean, that's the price you pay for the privilege of doing that.
Or you change your website and remove that from your website.
I'm not saying I'm right. I'm just saying that's my opinion.
I agree with that opinion.
The complication that we had is that in instances within both the law and the rules, sometimes it says offer or perform. Other places it says perform. And I think here he's not performing. And if those rules had actually said offer or perform, I got him. But it doesn't. It says perform. And he's just, we have no indication that he's performing. And I don't think we can go after him for maybe performing. I think there is potential harm, but until there is harm, I don't think we can do anything.
What about the plan to perform on the application?
On the application.
And to provide, and
why would you have it on the website if you're never planning to provide it? Unless you're trying to mislead. I don't see how there's anything other than it's black and white to me. You're either planning to provide it or you're misleading. And in either situation,
I will. If the board would like to amend the recommendation here, and if the board wants to vote and approve that they feel this to be misleading, then I can go after the advertising, the rule that we have on misleading advertising. And we can certainly pursue a consent order through that. This is just my recommendation based upon the complexity and the discrepancies within the rules. These are not the easiest things to follow for me. So I can see how people out there could find or think they found a loophole. I can understand that. I think this guy may think, hey, I've got a firm permit. I'm good. I'm not actually performing, and so I don't have to be in peer review. I think that's a reasonable interpretation. I don't think it's the right thing to do, and I think that's why we have this misleading advertising rule.
To me, it seems like advertising. So if we think we have a legal ground to actually do that, go forward on misleading advertising, that seems appropriate to me.
I'm the threshold to think if I think it's misleading or not, and I was like, I think it's walking right up there. I wasn't comfortable flat out saying, and if you guys would like to amend this to move it into a consent order and propose some sort of discipline for misleading advertising, that is not my call.
It depends on how he's got it presented on his website. If he says if his website says we offer these services, or if it says we provide, it's different. I mean, if it's just offered but he's not doing it, he may really be an honest person and he just wants to see what's out there. And if nothing good comes along, he won't ever offer it. But if something great comes along, he will.
How is that not planning to provide if the right offer comes up?
I think the application says, do you plan to provide it?
Right. But if you're offering it to see if a good opportunity comes up, doesn't that mean if a good opportunity comes up, then you're going to provide it? And so doesn't that mean you're planning to provide it? I mean, it's okay to disagree with me. I mean, like I said, y'all are the professionals that do this. I'm just this smacks to me of
without
misleading
knowing the person
advertising.
and what his objective was, it's hard to say. I don't know, but he may be trying to make his advertising as general as possible to allow for folks to come in.
And I think that's totally okay as long as, in my opinion, if you're going to offer to do it, then you enroll in peer review. At that point, there's no limitation on what you're offering to do. Now, you may have limitations on actually signing an engagement letter if they don't have the competence.
The application goes one step further though and says if you do perform.
I would just think if the firm owner wants to do the right thing, that they would remove that service from their website as an offering, or enroll. I mean, that's just to me, if they're off, that's what you're doing. The whole website concept is to market and offer services, and if you list it on there, then you should be able to do it.
Does the ad say we offer audit compilation reviews, or does it just says?
It's pretty lengthy and descriptive.
I mean, he's admitted, according to this report, that the only reason why it's on there is for marketing purposes, which is a synonym for advertising to me. So it seems to me like if there's an opportunity to look into whether the advertising is misleading or not, it may not be, but it seems to me like it's worth at least looking into that. Again, I'm one voice, though.
I think you have a hard time going after this guy, because I can see where somebody do a website where they say they offer those services, and then they say, well, I'm offering them, but I haven't actually provided any yet. So because I haven't provided any, technically I don't have to be enrolled in the peer review.
I think that's probably
at the point I provide those services, then I will be subject to peer review requirements, and I'll have to get enrolled. But I think you have a hard time.
I think that's true if all you're looking at is the substantive yes or no you're providing them. But if you look into the advertising piece, then the question is the advertising misleading? And my argument would be that a reasonable person would think that if somebody's offering a service for a marketing or advertising purpose, then they have the competence to actually provide that service. Otherwise, you can't follow through on your advertising, and that seems to be some type of fraudulent activity to me. And that's a big power charged word. I don't know how else to say it. It's deceiving, at the very least. So while I think that may be right on the substantive issue, I think there's another issue that's somewhat related, but it's the advertising piece of it.
I could see a small practitioner out there is trying to grow his practice, and he chooses to offer those services, but knowing that the minute he performs them, he brings on a new layer of cost. And so you wait until you economically can say it's time for me to start doing compilations and reviews or some small audits. And when I do that, I've got to incur the cost of having this peer review. So, but you won't have to go back and redo his whole website, and his whole marketing scheme, when he reaches that point. I don't know. I just think it's a gray area, and unless he's violated the law, I think we.
There's 3 CPAs on staff there. 2 of them have 25 years of experience. One of them has. I would be happy to do whatever the board wants, to be honest with you. I do think there would be some complications in terms of prosecuting this guy, because he goes, show me where in the law and rules I can't offer that I do this, and I have to be enrolled in peer review if I offer to do this. And all we're going to be able to say is that, well, the lecture law and rules say, if you perform it, you have to be enrolled in peer review.
But wouldn't the basis be advertising? Misleading advertising?
So, yeah, absolutely.
I mean, you could concede the point on the substantive issue and go after anyway, I'll let it drop in there.
Someone has complained about this. Is that because they've tried? I mean, I don't know the nature of the complaint.
A competitor submitted information. What was it named?
They're in the same area.
And that was my point earlier. So like if we do this with a letter of warning, then are we opening a door that every non-attest firm is going to start advertising they do this? And if so, then how are we going to already monitor what sounds like a complicated process of people coming in and out of peer review, sometimes not even actually going through peer reviews because they want to do 1 or 2 or 3 of these engagements? I mean, how are we ever going to monitor it if everybody starts offering it and we don't know who's actually doing it, who isn't doing it? I mean, to me, what our job is, one of our jobs is to protect the public, right? And the people that rely on the professions to vet these companies and look into them. So my question is, do we think there's more likely of a chance that there'd be harm to the public if we allow this to happen or not? My opinion is that it's more likely that it would harm the public. And as a result of that, I think more than a letter of warning needs to be done.
Can it be addressed in terms of professional conduct rather than, because if we're talking about misleading advertising and the rules of professional conduct, rather than trying to state this gray area?
I think the professional conduct would be reflective on individuals' license, whereas the misleading advertising is associated specifically for firms. So, I mean, I am happy to go after this. We just need a motion to amend the recommendation. That's all.
Maybe just trying to be open and flexible about what his services are. He just hasn't the right client just hasn't come along yet. But he wants to make the public aware that he can do them. And it sounds like, and here again, we don't know if he's got people on there with 20. This is one of those cases where it's hard to sit here in a room, all the facts, and make a judgment call. Worthy of just a phone call to the guy and talk to him about it.
Well, I think that's kind of in essence what the letter of warning is going to say. Although technically, according to these rules with regard to peer review and firm permit registration, you're fine. You are walking up to, if not over, the misleading advertising.
I still have a hard time with that because, I think somebody out there starting a CPA firm, trying to grow a young firm, and even firms that have been around a long time that have got just 2 or 3 CPAs on staff that have the ability to offer those services. I mean, they're certified, they've met the experience requirements, they meet the continuing education requirements to offer those services. But they don't do it because they know that once they start, they've got to incur the peer review cost. And so it's an economic decision, and maybe you grow your firm to a certain size, say, now we need to get into that kind of services. But the peer review requirement only happens if you actually perform them. And I just don't have a problem with somebody having that on their website, that they have the capability and can offer those services. If they choose not to until it's economically justified, what's wrong with that?
They actually have the capability of offering and providing those services because they haven't at the time they're making that point, that statement, they haven't enrolled in peer review. So they actually aren't capable of actually providing the service.
Not providing the service. They're not providing the service. It's just like my Chevrolet dealer advertising that he can get you a Ford, but he'll buy the Ford dealership when he gets enough people asking for him.
Yeah. But if you're qualified, I mean, if you got your certificate, you've got a registered firm, you've met the education requirements, you can do it. I mean, you're qualified to offer the services when you choose to.
Get peer review qualified in a matter of days.
Yeah.
I guess maybe I'm looking at it too legalistically, but if you have 10 steps to qualify, so you've got to get a bachelor degree and 150 hours and certified, and you got to do all this stuff. Well, one of those things is you got to enroll in peer review. And until you've done all 10 of those, 90% isn't enough to say you're capable of providing it. You may competently be able to do it.
You don't have to do the peer review until you actually provide the services.
enrolled in peer review to provide the services.
That's
my
right.
understanding. You don't have to actually do the peer review until you actually provide it, but you have
That's
to be
correct.
enrolled in
But
peer
you're
review.
qualified to offer and can provide them up until the point you do that. You don't have to be in peer review.
Though that before you can actually say you're capable of providing the service, you have to be enrolled in peer review.
That's not what the law says.
I think that's what you just said. You said
No.
you have to be enrolled at it before you do it. So that means that because you have to take an action before you can actually do the service you say you can do, by definition, you aren't capable of doing that action.
Offer to do them before you're enrolled.
I would argue that that's misleading advertising.
My confusion.
Yeah.
How long has this firm been around?
We were first licensed in January of 2010.
That's not to say that the web.
Oh, so you're looking at their application,
I have their license.
their firm permit, where they answer
Yeah.
those questions about I can't remember if it said, do you plan to provide, or
I look at the section regarding the what is called profession-specific data in our database. There's an area where the firm permit coordinator toggles experience approved or not, and it is checked that the experience for the resident manager is approved.
Which means they provided experience in a test work, correct?
I have received calls from CPAs who don't typically offer a test work because they've had someone ask them to do a service for them, and they want to find out how do they enroll in peer review in order to do that.
Is that a material amount of money? I don't know what that costs for peer review.
Actually, to enroll with TSCPA, now if it goes to another state, it's hard to say, but if you enroll as a non-attest firm currently, like you don't have anything, because you can only be assigned a due date if you have work, you've performed work. So if you enroll as what we call a no ANA firm, it doesn't cost you anything. There's no fee. So as we revisit rules, it might be worth considering simply because it's a matter of filling out some paperwork. Now, again, if this administration goes somewhere else, I can't say there wouldn't be some nominal fee, but the extensive fee is incurred when you have a peer review.
Okay, well, I think that makes it pretty clear. It doesn't cost him anything to be enrolled until he actually has to have a peer review. So it would seem to me, I mean, I'm not on the committee, I don't think, but it would seem to me that if he intends to do it, he should be enrolled.
The relevant basic requirement in rules states for peer review, each firm location required to hold a permit to practice under Tennessee Code annotated section 62-1-108, which performs attest services. And that's where my problem is that of the other areas it says offers or performs, and this just says performs.
What does the advertising piece say? Because that's the only part that I agree. I completely agree with everybody's point about the
So if you want to know what the
substance,
advertising
but
rule says?
the point is the misleading advertising.
Mm-hmm. 1 second. Licensee shall not seek to obtain clients by advertising or other forms of solicitation in a manner that is false, misleading, or deceptive.
And there's no cost for him to do it. I mean, I think that's pretty straightforward. I mean, why wouldn't they go ahead and sign up? Why wouldn't they? Either remove it or sign up. There's no cost until it actually occurs.
I'm just the chair of the committee. Somebody can make a motion to do
I
whatever
think
you
there
want
is
to.
a cost to be enrolled in the peer review program.
Okay, so if you enroll,
I pay a fee.
yes, Yes, because you have a test work.
Yeah.
So if you had filled out your application to enroll and claimed that you weren't doing anything yet, then you can enroll as a no A&A firm.
Okay.
And those folks are not charged the annual fee, or do they have a reviewer fee yet? Because they're not undergoing a peer review. So there are currently maybe 90 firms or so in that particular category. And then what happens is the administering entity sends them a letter once a year that says, hey, we have you in this status. Please note below that you still have not performed any work, or check a box for the item.
So you can enroll and not perform this, and that's when there's no fee. Okay.
Then you can advertise that you're enrolled in the peer review.
Right. Yeah. And that's probably why it's like that.
There's extensive language on there that if you lie about what you're going to do, then you'll be,
Well, maybe this is not a good example, but I've been trying to sit there and think of a good example of something similar. But let's say you do tax services and that's all you do. And your website says we do all federal and state income tax returns. Well, you haven't yet bought the state software for Kentucky or Virginia, but you can get it. So your advertising says we perform all federal and state income tax return work. Is that misleading? All you got to do is order it, get it. You don't have it yet, but you can get it.
I think that in that particular situation, that to me is, you're going to perform any state tax returns that someone brings to you, and you're ready, willing, and able. It's not going to depend on the price someone's going to pay you. You're just going to.
You could turn it down if somebody came in and you didn't have that software yet. You could say, well, I don't think I want to get that one.
You got to buy the software, and you got to train somebody to do it, and so you might say, well, I got to do Kentucky returns. I think it'd be hard to go after this guy because I think he's within the law based on what's been. It was misleading advertising. He could say, no, we do offer those services. We just haven't found the situation yet that economically justifies us, because there's a hidden cost to peer review, because then you got to worry about what are the specific peer review requirements to make sure I all this in accordance with standards. There is some.
They might not be willing to get a peer review for a $5,000 audit, but for a $50,000 audit, they might.
For the sake of beating a horse that we've been beating, a dead horse that we've been beating for quite a while, the difference that I see, and I think there's a salient point, but the difference that I could see is that if you're offering a service, or you're saying I provide the service, or whatever it is, if the only thing between keeping you from doing the service and saying you can do the service and actually doing the service is a private one-off commercial transaction that's relatively real time, versus there's a regulatory box that I have failed to check at this moment when I say I can provide it. That's different, right? Are you legally and regulatorily sound and capable of providing the service? You may have all the competence in the world, and you may have been an audit partner at a Big Four firm for 25 years, and you've gone home to your hometown Main Street, and you have the ability to do it. But until you've checked every single regulatory box that allows you to do it, you by definition are not capable of doing it.
But just like with the CPA exam application, we're saying we let people take the exam if they get the degree. How is that different from saying if you do peer review, you got to file and get the peer review certification, but until you do a compilation or review or audit, you don't have to?
Well, if you're going to say that I can offer an attest service, then I need to, apparently no cost and no review transactional cost to me, can enroll in the peer review piece. Go for it. Be my guest.
Logically, that makes sense, but there's no requirement.
But I would say that absent you taking the logical path and doing it, then I would argue that that's when you open the door to have your advertisement be considered misleading. It's a nuance. Perhaps I'm making too much of the nuance, but it's a nuance that's convincing to me. I would just ask him to turn the page and read the rule on advertising and follow that one to the letter of the law as well.
Did the respondent actually say that he only has this information on his website for marketing
It
purposes?
says it right
Where
here,
did that?
the last
I know. Where did
paragraph.
that? I mean, he actually said that.
Right. In the response to the notification of the complaint.
That alone would upset me.
But yeah, and that's to me that's the biggest problem. It's like I don't have any intentions of doing this. I'm just advertising it. So if you have no intentions of doing it, don't put it on your website. You're not gonna do it. It's misleading.
When you say that, you say I have no intention of doing it.
Well, it says the last
For marketing
sentence.
purposes.
Well, that's not the same thing as saying I have no intention of doing it.
He said it's for marketing. Whether I agree.
That'd be my interpretation.
Another thing that I kind of think of is that, as Mr. Stewart said, he could do it. Perhaps he's waiting for an economically advantageous position. He'll never get that if he can't offer it.
But then why say the information is only on the website for marketing purposes?
Why not enroll in a cost-free?
Well, he didn't say at
review
this
fees?
point. He just said it's just there for marketing purposes. He should have said that.
If we voted to make him, to have a recommended consent order, the worst thing that's going to happen is he'd maybe fight it and say no, but it could be that he says, wow, I really need to just go on and do this and enroll. Right? I mean, that's really what we're looking at.
Maybe he doesn't understand that he could enroll at no fee.
At no cost.
I mean, I wasn't aware of that, so I mean, I don't know where you find that. But.
The reason for my recommendation is that there's been no prior history of disciplinary action, and that this is a really tenuous, whether it's misleading or, as we can see, there's a lot of discussion back and forth, right? And as far in his defense is going to be, I'm following the law and the rules to a T with regard to peer review and firm permit.
I'm not breaking the law.
I'm not.
It's getting quite late. It's 5:15, and we've got a number of cases to go through yet. It's obvious there are very strong feelings on different sides here. Is there someone that would like to? Would want to vote on the other three cases in this category, and then would somebody like to make a separate motion with regard to this case, and maybe we can move forward? I'll entertain a motion that we accept legal counsel's recommendation of cases 12, 13, and 12, 13, and 14.
I think there's a motion on the floor that I made, and I would amend mine to just cover those three.
Okay, we've got a amended motion. Is there a second to that amended motion?
I'll change my second to second that motion instead of the first motion.
Okay, all in favor? I guess we need a roll call vote.
Janet Booker Davis.
Aye.
Larry Elmore.
Aye.
Gabe Roberts.
Aye.
Don Royston.
Aye.
Casey Stewart.
Aye. Okay, with regard to case number 15, the chair would entertain a motion to amend legal counsel's recommendation if someone is so inclined.
The motion would be that we as a committee recommend that legal counsel go back and see if there's a legal reason or legal grounds to do something more than issue a letter of warning on the basis of false misleading advertising or any other basis.
Then we got a motion. Is there a second to that motion?
I second.
Got a motion and a second. Any discussion, further discussion?
At the risk of making it go even longer, I have a question. The recommendation that's there now says close upon the issuance of a letter of warning regarding misleading advertising. So what were you going to do? Were you going to say you need to be careful about your advertising?
That's correct, sir. I
Isn't
was going to
that
say
law-
that
isn't that
although you seem to be in line with regard to the law and rules pertaining to peer review and firm permit application, this could be construed as misleading.
what you guys are asking for?
I would say to open a formal hearing with the authority to settle with a consent decree, assuming that actions change to avoid to get rid of the misleading piece of it. Either enroll in the free peer review process, or take it off your website and quit offering it. I would leave that to, that's my recommendation, is to legal counsel to see if there's something other than a letter of warning to know that, because I don't know if we know the answer to that.
That would be, I mean, that's it. You
Okay.
just, I mean, if that's your motion, that you want to motion to recommend formal hearing with authority to settle with a consent order for how much money, or
if they were willing to do one of the two things, it seems there's no reason to give them a penalty. The point is just to get them to change their action.
Not already have a second on it?
No, we got a second.
Yeah, we have a motion on the floor.
Any further discussion of the motion?
They have to be amended now.
Okay, the initial motion was for legal to research possible action for false advertising, and then Mr. Elmore asked me a question. So if there's a motion to amend, Mr.
Yes, I'd like to amend what you just said.
With the recommendation for formal hearing with authority to settle, with either the respondent removing such language from its website or enrolling in the free peer review.
That's right.
Okay, we've got an amended motion. A second to that amended motion.
I second.
Any further discussion?
Janet Booker Davis,
Aye.
Larry Elmore,
No.
Gabe Roberts,
Aye.
Don Royston,
Aye.
Casey Stewart,
No.
Motion passes 3-2. That'll be the recommendation to the board.
Okay, good. The next 11 cases involved, basically involve recommendations for formal hearing for revocation of the CPA license with authority to settle via consent order with payment of civil money penalties. The first case, and we'll probably take these, go ahead and take them one at a time, but the first case, number 16, deals with a complaint against the respondent for failing to respond to requests for records from a client and failure to provide those requested records to the client. The investigator confirmed with the complainant that several records were still missing and outstanding. The respondent was uncooperative with any investigatory efforts. I believe investigator did make several efforts to contact respondent by email, telephone, and in person. So basically got an uncooperative respondent. Again, the recommendation is for a formal hearing for the revocation of license with authority to settle with a consent order and payment of a civil money penalty of $1,000. Does anyone have any questions on that case?
Would it be appropriate for them to provide the documents they haven't provided in addition, or is it just a fine type thing?
My memory serves me correctly, the respondent is in communication with the complainant, just won't respond to us. And he provided volumes of materials, even some of which were and I think the complainant is actually not the client, but the new CPA for the client. Yeah. 2 clients. And so the respondent is providing, I mean, I don't know how many hundreds of pages it was, like 800 pages. And we had asked the complainant if everything was there, and I think nearly everything was there, and that they were still working with the respondent on getting those.
Okay, any other questions?
Motion to accept the legal.
Let's maybe try to vote on all of these at one time, Gabe. They're all very similar, and we might pick up the pace here in a minute, I hope. But case number 17, the complaint against the respondents for the use of prohibited title or designation because of prohibited language in the respondent's sign and the respondent's lack of firm permit. The respondent responded apologetically and stated that it contracted with a sign company to have their sign changed. The respondent does not have a firm permit, and respondent was previously issued a cease and desist letter in January 2014 for the same exact issue in this complaint. Okay, so you got prior disciplinary action. The recommendation of legal counsel is a formal hearing for the imposition of civil money penalties with authority to settle via consent order upon the respondent's payment of the civil penalty amount of $1,500 if the respondent removes the signage and provides proof of the removal within 90 days. Otherwise, the civil money penalty would be $3,000 or double that amount. And it's not a licensed CPA, so we can't revoke their license. I mean, our only option here is some civil money penalties. Any questions or?
Was there a consideration for some type of escalator on the $3,000 if the decision is indefinitely leave the sign there? It may say $3,000 is worth it because I've got an advantage over my non-permitted folks. So is there something like after 90 days and then it's 3,000, after 100 it's 3,500, after 110 it's 4,500.
If they agree with the consent order for the 3,000 and sign it, and after 90 days it's not there, we can reopen it, bring the complaint, and do it again. If they refuse the consent order entirely, and then we can pull them in for a formal hearing, and the penalties for that is up to $1,000 per day per violation. And I don't think the sign has changed since the initial cease and desist, whenever that was, in 2014.
Questions on that case? Case number 18, the board staff oath to complain against the respondent after becoming aware the respondent's Alabama CPA license was revoked for failure to renew. On the respondent's last Tennessee renewal form, the respondent indicated no to the question of discipline from another state. The respondent also has failed to respond to any and all communications with regard to complaint. So basically, council is recommending formal hearing for revocation of license with the authority to settle via consent order and payment of a fine of $1,000.
I'd like to see that, unless there's prohibition to it, that number higher. I want to set a standard that they need to reply. If they're ignoring you, it's not going to be a slap on the wrist of $1,000. If we've got more latitude, that's my thought since I'm on the committee.
We have more latitude. My reasoning behind the $1,000 is that the license was not revoked for any sort of professional services rendered. It was just a failure to renew.
But he's ignoring you now. Is what.
But I don't necessarily know that the addresses that we have on file are current, because this individual, I think, is seeking a letter of good standing from us to get a license in Florida. So I'm happy to do that if
he's responsible there again for notifying us.
I agree. I'm happy to. If you guys have a motion to change it, I'm happy to do that.
It's late in the afternoon, so maybe.
Other thoughts or comments you want to throw them out, Don? I'm happy with the recommendation as it is, but you're on the committee.
It's a suggestion, and other members.
I'm okay with that. I just don't know what amount would be proper.
I was, look like $2,500 or something, but I'm not hung up on it either. So.
Mr. Chairman, if it makes you feel any better, if they continue to not respond to us, likely we'll have a formal hearing with an order of default and just revoke the license entirely.
Let it go. Go ahead.
Case number 19. Complaint against the respondent firm alleging that the respondent firm is offering compiled financial statements without having any CPAs on staff and also without having a firm permit. In the I think situation where the attorneys got involved, the attorney for the respondent or the respondent indicated through his attorney stated that it acknowledged that the mistake of including such words as compilation on the website, and it has since removed them. The respondent states that it has removed all offending language from its website. Respondent has 2 previous complaints, one for unlicensed activity in 1995 that was closed without discipline, and another for unlicensed activity which was closed upon the issuance of a cease and desist letter. Again, recommendation here is for formal hearing for the maximum civil penalty with the authority to settle via consent order upon the respondent's payment of the civil penalty in the amount of $1,000. And again, this is not a situation where we can revoke the license. It's an unlicensed person or firm. But any questions on that one?
The maximum civil penalty is at $1,000.
No, ma'am. The maximum civil penalty we can seek is up to $1,000 per day per violation, with each day of the violation continuing being another violation.
Since this is third strike, I would make a motion that we make it $3,000. His attention.
Well, yes, sir. Mm-hmm. The reason why I put $1,000 is because they responded immediately and complied and changed their website. So I'm happy to do whatever.
He's responded immediately the past 2 times too, though.
I think this is super important because it's like number 15. It's interesting, though, to see the complete difference in behavior and responses, where this one immediately says, yep, our bad, we didn't do this, instead of holding on to some tenuous argument that they're okay to do it because they could offer this if they wanted to become licensed, et cetera, et cetera, et cetera. I guess my question is, have we confirmed that all the information is off the website? All right.
Both feel like Mr. Royston want to change the amount?
Eyes for lack of a second. I'll hush. Let's go home.
Answers are looking better, aren't you, Don?
Yeah.
Number 20, the complaint against the respondent firm for failing to be a licensed CPA firm and for failing to be enrolled in a peer review program, but having performed a financial audit for the period ended October 12, 2015. The respondent firm was notified of the complaint and responded, admitting the failure to be licensed. The respondent has since registered as a firm and has enrolled in peer review. The respondent holds an active CPA license with no history of disciplinary action on either.
What's the typo?
Also, the respondent firm has submitted an application for a CPA firm permit and has submitted an enrollment form for the TSCPA peer review program. And recommendation is for a formal hearing for revocation of license with authority to settle via consent order and the payment of a civil penalty in the amount of $1,000. So,
I think it's the exact kind of harm we're trying to avoid in 15. And actually, my question is $1,000 enough? And is that enough of an incentive for us to avoid this churn issue that keeps coming up where people enter and then they leave and enter and then they leave and the peer review piece? But if y'all are comfortable with that, I mean, I would be comfortable with it. I just don't know if that's a consideration you had when you were going through it.
I usually take into consideration the timeliness of the respondent's response and their actions to fix the problem into my consideration for these things. And usually when they do that, I say, okay, fine, let's do them with $1,000 so we do at least hit them for something. But most importantly, we're getting them compliant.
Right. I agree. That's the most important thing. Good with me.
Case number 21. Complaint against the respondent firm for failing to be enrolled in the peer review program since 2010, but having performed an audit for the period ended December 31, 2014. The respondent firm was notified of the complaint and responded, admitting failure to be enrolled. The firm explained they don't realize when they submitted their application to the board that it would not be forwarded to the ACCPA for enrollment. A respondent firm indicated that it was taking steps to become enrolled. I take that to mean when they thought they applied that it would just automatically go to the ACCPA. They would become enrolled and be notified when they needed to have a peer review. So, recommendation here is for formal hearing for the revocation of the respondent's firm permit with authority to settle with a consent order upon the respondent's payment of a civil penalty in the amount of $3,000. Now, that's 3 times the previous penalty.
Yes, sir, because the respondent only asserted that they were taking steps, whereas the other 2 firms took steps and were enrolled.
In addition, I think I may have suggested on this one, because they did not have a peer review, that was the cost of the peer review.
They also admitted since they had not been enrolled since 2000.
Thanks for clarifying that. Any questions on this one? Okay, the next, starting with case 22, and I think going through case 26, they're very similar. They're all involving CPE, failure to have the submit the required CPE to the board. They basically didn't respond to either the initial audit notification or the last notice that was mailed out, and the respondent has not submitted any CPE for, and these all deal with the period 2013 and 14, so maybe we can basically cover them all together. The recommendation, like on case 22, is for formal hearing for the revocation of the CPA license with authority to settle via consent order upon the payment of a civil penalty of $1,000. And then further, as part of the consent order, the respondent shall be required to submit proof of completion of 104 hours of CPE within 180 days. And that 104 hours is the 80 hours that they were required to submit, plus 24 penalty hours. Is that correct, Wendy?
Yes, sir.
Okay. So case 22, 23, 24
to 26.
Actually, right, all the way to 26 is all basically the same recommendation and the same fact situation regarding CPE. So failure to get CPE. Is everybody okay with the legal counsel's recommendation on those without discussing them one by one? Okay, we didn't have any changes in this.
16 through 26.
I'd like to make a motion that we approve or make a recommendation to the full board that we approve the recommendations of legal counsel for 16 through 26.
Second.
Okay, any other discussion of the motion? We'll have a roll call vote.
Annette Booker Davis.
Aye.
Larry Elmore.
Aye.
Gabe Roberts.
Aye.
Don Royston.
Aye.
Casey Stewart.
Aye. The next, the remaining cases, there are 8 of them, 27 through 34, deal with representations, and I'm not sure I know exactly what that means, but I know there's some new members on the committee that probably don't know either. But what kind of, if you give us a little bit of background and what that means?
Yes, sir. These are cases where one of a few things has already occurred. The board has already approved, for example, the litigation monitoring consent order, and perhaps the litigation has ended, or some other new facts have come about, which have made me decide to represent these to you all for an alternate disposition. Some of them have been moved into litigation. Those that have been moved into litigation, the litigators have come up with, talking with the respondent and their attorney, additional facts which we felt that the board should consider.
Basically, these are still open cases at this point, though, until we
yes, sir.
vote to close them. They haven't been closed and they're reopening. They're still in the open.
Yes, sir. Cases are only closed if, like the first, I think, 10 or 11, where we initially just close them, a letter of warning, those things automatically close. If the board authorizes a consent order, once the respondent pays the civil penalty and signs a consent order, then they're closed. Out there, and some new information has come to light, rather, which has made legal decide that perhaps representation was worth the board's consideration.
I have read these and hope you have, and I would like to maybe just go through them the way I would go through them. And if you want me to slow down and we'll go back and talk about it more specifically, we will. But like case 27, this is one that was placed into litigation monitoring, and I think that situation says legal received an order granting voluntary non-suit by the plaintiff, and so basically litigation's been resolved, and legal counsel is now recommending to close the case. So go to 28. And there are a few, I guess the next 2 or 3 might be the same thing, but it's failure to pay the professional privilege tax, and the board decided in October 2015 to no longer open complaints for unpaid privilege tax. But I think our position now is you cannot renew your certificate or permit to practice if you haven't paid the privilege tax. So there's no need to keep this complaint open, I think, is the situation now. So number 28, legal counsel is recommending to close the complaint. Number 29 is the same thing. There was unpaid professional privilege tax from 2011, 14, and 15. And so basically legal counsel is recommending to close that one. Number 30, the respondent reported that he was a party to a civil suit, which is grounded upon the allegation of gross negligence, dishonesty, fraud, and incompetence. And basically, new information, the allegations in the lawsuit are clearly not in reference to any professional services that the respondent rendered under his CPA license. In other words, I think this was from him maybe serving on a board of some kind, and somebody
Volunteer member of a board of a hospital.
Yeah. So it has nothing to do with rendering CPA services or using his certificate in any way. And so the original recommendation was to place into litigation monitoring status, and legal counsel just simply recommended we close this complaint.
Mr. Chairman, for the record and for safety, I'm going to recuse myself from number 30 from the vote.
Any other comments or questions on that one? Number 31, the respondent reported being a party to a civil suit, which is grounded, that's not very similar, but grounded on an allegation of gross negligence, dishonesty, fraud, or incompetence. The new information, the respondent's attorney provided legal with a copy of an order of dismissal as to the respondent. And so that was in litigation monitoring status. We're now recommending close the complaint. Okay. Number 32, complaint alleges multiple instances that respondent lied about complainant's income taxes, stole income tax refunds from the complainant, failed to produce complainant's tax documents, et cetera, et cetera. The detective, I guess, from the sheriff's office that investigated the claims indicated the DA's office will not be filing criminal charges against respondents, so he's not going to be criminally charged. The new information, respondents agreed to sign a consent order admitting to grossly negligent accounting work. Additionally, the respondent has agreed to voluntarily surrender their CPA license and accept an indefinite bar on the respondent from submitting a new application for licensure. Respondent is in the process of filing Chapter 7 bankruptcy and is verified to be in extremely poor health. The original recommendation in this case was for formal hearing to revoke the license with authority to settle via consent order and the payment of a civil penalty of $7,000. The current recommendation is to accept the settlement via the consent order, voluntarily revoking the CPA license and invoking an indefinite bar on the respondent's reapplication for licensure. So that was a little more complicated, but the questions are.
Can we do I mean, obviously, if it's in here, we can do an indefinite bar, but I thought the statute said 5 years they could reapply.
5 years max suspension.
Suspension, but not. Okay.
Yes, sir.
Thank you.
Any other questions on that one? 33. The respondents originally were named as defendants, along with many others, in a suit alleging fraud involving subprime loans. New information has come about. Legal conducted an additional review of this complaint and the supporting material. The allegations from the lawsuit are focused on actions taking place from 2004 to 2007. The respondent's CPA license expired December 31, 1998, and the lawsuit does not allege that the respondent used his CPA license, whether properly or improperly, or that the allegations are in any way related to the respondent's expired CPA license. So this is dealing with actions that took place several years after his license had expired. Originally it was placed into litigation monitoring, and legal counsel simply now recommends that we close the complaint. Any questions or thoughts on that one? The last one.
What we've been looking for, isn't it?
But it's more complicated. Yeah, I had to read this one a couple of times, but we may ask legal counsel or somebody to talk about this one just a minute. But apparently there are 3 complaints involved in this one, 3 cases.
Yes, sir. They're all filed within about 1 or 2 months of each other.
They're all the same respondent, or?
Yes, sir.
Okay. And but basically, the complaints allege that the respondent committed acts discreditable to the profession and is practicing on an expired license. It's alleged the respondent abandoned her practice and has not communicated with clients, leaving several clients unable to file their returns, both business and personal, and has not returned the records to the clients. She also failed to respond to the complaints and repeated attempts by the investigator. New information that's come about. Apparently, this is a lady that was going through a divorce. There was some sexual abuse or misconduct.
Not from her spouse at the time. She was raped. She was involved in a sexual assault.
Okay. But there was a divorce proceeding involved in child custody matters, so there were some mitigating factors. But basically, she hired someone to consult to help liquidate her practice, which looked to me like did a lot of the right things, appropriate things in terms of contacting clients and making an effort to give people what they needed and do the best she could. Now, the original recommendation here was for a formal hearing to revoke her license with the authority to settle with a consent order and a payment of a $10,000 penalty. And the current recommendation is basically for a formal hearing for the revocation of the license with authority to settle again with a payment of a $10,000 penalty. I know you're about to comment. I thought that was rather high in terms of considering all the things she had done to.
Well, excuse me. The original recommendation was not only a $10,000 civil penalty, but a voluntary revocation of the license. If the respondent would not want to agree to that, then we would pursue a formal hearing for revocation of the license and civil penalties for the violations. The current recommendation is that in light of these mitigating factors, violations did occur. And in light of the mitigating factors is to not seek a voluntary revocation, but solely the $10,000 civil penalty.
Wants to settle this thing, I think. That's
correct.
I did not read that in here, that she wants to resolve this without a formal hearing.
That's correct.
Do you know if she is she agreed to this?
Yes, sir.
Penalty amount?
Yes,
so,
sir. Mm-hmm.
Well, then let's don't read it. I just thought the penalty seemed awfully high in view of all the things she had done, but I knew there must be other factors.
Well, there was, she had not properly renewed her license during this time period. She continued to operate and hold herself out as a CPA during this time period. We had these 3 clients of hers who did who actually had a very similar experience to what our investigator had in trying to reach this particular respondent, and means like calling repeatedly, calling the numbers she provided, not getting information, not getting the records for their taxes, waiting outside of her office for hours on end in the hopes that she would pop up.
There are plenty of facts there to support that penalty.
That's correct. And so although the majority of her clients were handled in a very professional and appropriate manner, several clients had horrible experiences. And because of that, I believe the respondent is acknowledging that in those instances, but would like to retain her license. And so she had come forward and said that she would be willing to, through her counsel, agree to the civil penalty if the board, in light of the mitigating circumstances, would be willing to take off the voluntary revocation.
Anybody have any questions on that one? Any other comments? Okay, let's get a motion to approve the recommended disposition of cases. What was it?
27 through 34.
To 34.
Sure.
So in this last one, are we still taking away her license? It says
No.
formal hearing for the.
Well, that language is standard because she has agreed to 2 payments of $5,000 over 2 months, and so if she fails to abide by the consent order, then that still permits the board to seek a formal hearing. That language is on every single one of the recommendations.
I'm going to vote on cases 27 through 34, excluding those case number 31 that you need to accuse her.
30.
Was
Number
30?
30, yeah.
Okay.
About the hospital.
Number 30. Vote on cases 27 through 34, excluding case number 30, to approve legal counsel's recommendation.
Second.
Do a motion?
I'll motion.
Second. No, we got a motion and a second. Let's vote on it.
Annette Booker Davis.
Aye.
Larry Elmore.
Aye.
Gabe Roberts.
Aye.
Don Royston.
Aye.
Casey Stewart.
Aye. Okay, now we need a motion to approve legal counsel's recommendation on case number 30, and Gabe Roberts is going to recuse himself from voting on this one.
Make that motion.
Motion second. Any discussion? Okay, let's have a roll call vote.
Annette Booker Davis.
Aye.
Larry Elmore. Don Royston.
Aye.
Casey Stewart.
Aye. Okay, we'll entertain a motion to adjourn.
So moved.
Second.
We gone. Thank you.